right, cheme, kenyeme, mimba nyefe nye day, omanye, mihemi yake, nyefe nye ojogba, Marosina. Happy Mother's Day to you. Auntie Maggie, usuyo papa, Happy Mother's Day to you. Omami mefe, Happy Mother's Day, ke hanye fe, in liake nye yo Europe, ke other parts of the world there, nye celebrate nye Mother's Day omo, shiwameni, wa yo mane mini, Meneji or Mother's Day. And I want to take this opportunity to celebrate all the mothers on this platform. You guys have been amazing. You guys have been so supportive. You guys have been so encouraging. I could not find better mothers on a platform. Tomo nyemeni nyeyo BNN. So once again, I appreciate every single one of you. Happy Mother's Day. And of course, I cannot leave the two most important women in my life out. America, I want to appreciate you on this lovely day. Happy Mother's Day to you. You are the most hardworking mom I know on the planet Earth. You are the most intelligent. You are the most smart. I appreciate you and I love you so much, mom. And of course, I don't know how many people, how many men marry your mamime, but for me, I am a very fortunate man because the woman that I married is an exact replica of my mom. In everything, is an exact replica of my mom. So, in wife. It's like it's I don't know if they are two souls, and because these I don't know if they are the same soul, and because this particular soul lost me so much, it decided that it must split itself in ni efe imami ni at the same time and the same soul ebafe fatalo, right? So once again, Manya 1, Director 1, Mrs. Ashon, Obe Size. Happy Mother's Day to you. I love you so much from the bottom of my heart. Thank you for being the greatest mom ever. And once again, happy Mother's Day to all the mothers on this platform. Happy Mother's Day to Auntie Vic. Auntie Vic, happy Mother's Day to Auntie Vic. Thank you so much, Mofemo. Maggie, thank you so much. That's right. Happy Mother's Day, Mofemo. That's right. Aku Che is in the building. A wishy Mofemo. Happy Mother's Day. Yes, of course. Aku Che lose a mom about 2 years ago, I think. Happy Mother's Day. Ni ameke wobe wati amekume ni wamamime ke wobe don happy Mother's Day to them as well. If na me yo wanta na me liake, we love them, we appreciate them, and we cherish them a whole lot. Wanda me fan she wanna make any be fan. Yes, wanda I'm a fan she. We appreciate all our mothers and all our grandmothers, our great grandmothers. Well, I appreciate all my family. Me and called me down again. Here was second ejiwo. Here was bedroom. So yeah, can you bear while she let me? You see, your play is so smart. If you're not get bene, what shangele me fan, what shangway fan ni mugu bedon. Here was bedroom. Him back already. So once again, nye fe anawalada ukleje yanoni ejonye ake omamime ni nye yanoni sumo ni nye jiokpo ke ha wo nye je na kan sumo okpo ke awoda minda nye fe shi ekon tumobono le. Today is going to be a lot of reading, bona. But before ni woba kane menesane nye nkebo ake in a breaking news quote from Bessie. But a very important show. It is very important. So I don't want us to go into this just yet. She chombo. Ni wabane fe wa first show the coming week. Sometime last year, there is this I have to be very careful with the choice of words. Yeah, beseni ami ni ameani wana wale yake ameji the legitimate jase ni ameke petition ete ga traditional council ni ache ni ngbese keba jeme ni abile sanjin kenye ba kai what treat na kan story ya bi odogba. I did not only read that statement for you, I showed you a video of the presser that they released intra video saying abo ni se mi wona ni ama okpa babie ni eba respond to neke cheme ne benye before I start to show to mo benin kebo in the share document no, and I presume I can from the same chairman no ni challenge ni gbese legitimacy bona boni ni yo. So like I said, ismon work about futu ni ne mismoni ma kande fe mahabo. So I don't want it to I want us to treat it ojogba dencha on a topic of its own. Ni ma connect all the dots fe mahabo. Ma try my previous video I cover join we check allo yin pano ona I'm a previous thing ma fe mahabo. Nko boake bi waye pashi ai bi waye pashi ai bi. So ene amemma ye nigbese you all know my relationship with nigbese, but when it comes to my work, we don't care where you are no quality. So I will show you this document. The first show no about fair week name but so I want you to know okay in nation and we will deal with it. Tomoboni will deal with every other issue ni eba wakoya shishie bona boni ni yo. So be mindful. These are neke chemene I'm a lawyers G many egmaneke wolone kehani bese. And like I said, I will read it for you in my trouble. You know, well, I get me in I'll show you everything. I'm an earlier press akaba. Mama kandemabo. Masama tra. I'm a video. Kehabo. Leon onaboni ni yo. What so expect more a full show on this group of bese against Nigbese Nijinia Ibonte Nijinyo this week. This is Nidete TV. Where you are Nukwale, we don't care who you are, we don't take sides, we are only sticking to the truth. So I will give you everything. Nika response Je Nigbese Ngonke Bahue Leon Ma Ani Ole. Like the last time Onake Nigbese Fa Niama Ukpa Ni Eba responded to Ame. Ke Nigbese Sa e Fa Niama Ukpa Eko. Allo manoko in writing where mabama tabie ni makane fe mahabo. We have to set things right. We have to make sure ke totomo eni yano ye wo biane mie e yano don. Oh Ima, oh it was you. Oh okay. Hello Banye. Oh Manya blawa ima fine I'm a bena asma bo in the show no man when Eliaga go fly fine I'm a be show na my trouble. Oh no. Fine. All right, fine. That's right. Oh fine, you're my trouble. Okay. Oh, I see. Okay. Oh, really? Okay, but I'm a be sure na. Oh fine, I'm a be sure na. The microphone I got peaky. Do I'm a bena. Oh no, my trouble. All right. Okay. Thank you so much. Right, so mogo eba tanhi ni minchu nuchumone keke ni minchu tumoboni keni de shawolo ni kan yo ha boy eba tanhi the eba tanhi actually she was saying, but I don't really want to pay attention to le other body there yo but if you bag I will ngake ko tani the TV o ga jele mi fe ba nai. Yes, look, I'm not perfect. I will get it wrong. Before Jimmy, Bible epoge before I go me pu ameton ni mo shuabe. So I will get it wrong, but Kelba chastise me and make sure I am really, really, really wrong. You understand what I'm saying? Because if you step into it, I don't care who you are. Bona. So shata to your thing shata eba fit away shata get me you wa shata can go for that to have it. Anyway, so just so you know, we'll deal with this. You will I mean, we will deal with this story. It will be the first story, about fee. this week. I will take like a 2 days break. So I'm sure we'll be back here on Wednesday. Born near your yeah. So Uncle John, over the middle chon Maria no chon in tra. Alo technology. Actually Maria ene ni kena Jane Chinchin biene. Maria ene ni kena. So can no be ole but for the mothers again and for we fataloy echo nyani what try Maria to all the mothers especially our wives womami mele watcheme babi anye watcheme babi Maria anye she wo babi Maria bi ane or babi we fataloy so once again special request from Uncle John to all our wives. We want to celebrate. Happy Mother's Day. Let's do it again. Bona.
Only one energy, baby, we give up. She had just said, "Why not you be careful for Sunday? We don't show me, you know you me, catch a lady, get a gang of Shana. She looked on it, on me, what I need, be careful. Some more coming up when you meet the baby, and never make me try. Maria, I'll make it cry. You're funny, baby. She small, I only on the show, baby. Maria, got me, Baba. I'll make it cry. You're funny, baby. She small, I only on the show, baby. Maria,
Right. Shout outs to everybody. Maggie, happy Mother's Day to you, Maggie. Maggie, happy Mother's Day to you as well. Maggie Glover, Maggie Toyota, Boy Oduba. Nemisa, happy Mother's Day to you. Oh, Maggie ke enu noko. You find it mo fe mo nu Oduba. Be Maggie o find ke onu noko refresh mo ofi there because mo fe mo nu iye Oduba. Maggie, so often a refresh more of feed on class captain, often a tag more no kelage a refresh a feed am yonu ya shibami class captain, often a tag more Maggie a response a message any in a sound there clear no a refresh a feed in how ya shibami. Right, so look, this Sowutuom Sunday Ekesan P eba tamo boni wale Belena Bekani be nefe. You cannot onyo J1 yake no ke Belena Agbone fe Sandiba. You understand what I'm saying? So what we are going to do to Mobeno Lenin Kebwe last 2 weeks when you were established for a fact ake aseneme Sowutuom shiponji ndi amame no ani tamobono le amo me no agency, I believe from the early 2000s or so, abagbena 2019. So asenema no abagbena 2019. Now, ke okwe Sempe no Sempe case it actually started in the early 90s. So before ni aseneme ke Abola Piam be a boy shikon epelemo no me Sempe me ke Abola Piam be empele shikon yomo ni ameno abagbena 2017. So case travel over 20 years. You understand? For 20 years Sempe ke Abola Piam litigate neke Sowutuom shikonji ne. And once again, Tamo, shout outs to you, man Grace. Happy Mother's Day to you, man Grace. Ofane boy ojuba. Tamo boni Abola Piam be I'm a floor mina chol I'm a floor aseneme nakeno I'm a floor Sempe me. Now Sempe lost the case at the High Court. Ni at a High Court Sempe lose case at a High Court. Sempe no shishi. Na me work at the appeals court. Now me work at the appeals court. I'm a losing. So both times Sempe losing. So what I put the Sanjia me ni wakande. And of course, I'm gonna try my very best to magblami yagami to the best of my ability. This is about 40 pages long. So can we share any authorities fire jeme waba skip na kan authorities say okay what botemi can work benona. So this is the High Court ruling any or judgment. This is actually a judgment from the High Court. Ni ejeko 2014 High Court judgment ni ejeko 2014. No abakane first. Ke work bena okay what can the appeals court ni ayagbena in 2017. Now this is about 40 pages. So Yeshua keji waje mina chole waje authority say jeme ina site authority say baba oh yeah ni je ko esanjie keje. I'm sure will probably be down to about 25 pages. So it's a jeke to the other one and what kind of first time appellate court no it's only about 10 pages. So altogether, what call like a give or take, we're going to read about 40 pages. Last what kind of over 50 pages? What kind of 51 pages? The last time any of you cinema no. So let us get into it. And I love reading this because it tells you a story. You understand what I'm saying? If there is one thing that I've appreciated, court judgments ne kandemone. It tells you a story. So keji otauni olega, no lega history, no leshikwanji asane. Look, there is nothing better to fall back on or to refer to than the judgments ne ejio court say eba. It tells you the story of every people ni aye amesani again, and I love it. Like that's why the fact that actually it is very tiring reading it. But I love the story that it tells. So once again, if you want to learn more about Abola Piam, you want to learn about Sempe, you want to know the history behind these lands. Can it be money at Judgement fresh, money bana Judgement? Carefully coming can judgments, they can't be boring because you're going to learn a lot. Unless you big bag bush here, cause more big bash bush here. This will not be for you. But also bush here. Trust me. One candidate me is a no make time no but yeah ishibami bombaden koni o jadni fe mo kehamoko ni lewu ekehamoko ehawo ke o hako wo gontin awo gontin no ni ya anwe ko bombaden koni mina chole subscribe if this is the first time ni mo go ke link sendable ni oba join the wall kano oyin pano ni o subscribe to what channel so I'm gonna face this way. Connie Bolly, my protect imposture field than my failing again. Bona. So please pardon me. I can me face laptop because it can't get back here. So I want you to mention my face in again. So if I keke me. At least about one posture field than the last time I've been into here. So here we go. Again, the Superior Court of Judicature in the High Court of Justice held in Accra on Tuesday, the 15th day of April 2014, before a ladyship Justice Elizabeth Ankuma Mrs. Una suit number yejeme TRLD 45/10. Now, plaintiffs Seth Ankra ke Joseph Yaya Adi. Now, let me give you a little bit of a background. Ye neke lawsuit ne Mr. Seth Ankra ni onale yejeme, and I would say get time permit war wakele baba banulo Mr. Seth Ankra ni onaye lawsuit no. I'm going to try and see ake wabanye ni wakele aba banulo is still there. Wache yayade, I'm told ake ego last year. But wache Seth Ankra le ye. So if time permits, we'll bring him on after I finish reading. Koni komeni forging yo ni eba feel na kind forging ya. So Mr. Ankra came yake a case in 1990. So called the Sempe ni obomitwe, and I hope I Sempe me pi babo neke no connect because of noni it happen Sowutuom bona. So Mr. Ankra ni ona Seth Ankra is actually a professor. He's actually a professor, a very smart man. Le start neke lawsuit name 1990. So there many 1990 Tony a start neke lawsuit ne tomo boni ona ye nie mliem. Shout outs to you Amukwe ni Amukwe ofane to your turn from Deutschland diam you find boy ojuba. So 1990 Tony aje case ne shishi many Sunday 1990 I was a little boy in elementary school. Now nomie Mr. Ankra Kemia nomie Moniji Abola Piam we kunupa achole si obotri ni echonse Matthew Aloti wache ko na achole Matthew Aloti kenye ba akaye biamini kane Sowutuom ke asane bi a judgment wache Matthew Aloti ne ache egbe ake at one time he was Abola Piam onupa ni me I mean I conjectured okay ni me na alote ejemene and no ke Sempe connection there but this old shikmo pelemo if you guys remember 2 weeks ago le who echon say ni eshi ese eha Mr. Yaya Ade ni ona ye jemene bona boni ni yo. So this is Bonnie Nekeno Kone Jeshishi. Akemi wake abasend minoko from 2018 Lands Commission. Noni wanyeme asaneme yafe jeme no abani male keni nesheno no inkaba chombo. So this case started keje 1990. Ton. So jemene ajeshishi. Nyani wabotiami ni wakania. Bonnie wabanale. Now, so let's go. Mr. Seth Ankra ke Mr. Yaya Ade name amekete Moni Achole Kingsford Ajaben Michael Agbewale Fio ke Kwesi Ahiaku ke number 4th defendant onake Agma Sempe stool. So the entire stool I take me on and Obana no one take the entire stool on just looking at this Obana gebe no me ame on shikoji negeme etene ni before Agma ame no woni akame fete. So this was a case between the elders of Abola Piam ke Kingsford Ajaben Michael Agbewale Fio Kwesi Ayanku and the Sempe stool. So now I sue an individual from Sempe, but I sue the entire Sempe stool. Get this clear. I sue an individual from Sempe, but I sue the entire Sempe stool. Jimo ni asue. Engineer ne adoto tinto ofane boy ojuba. Nliake numwe ekwewo esumo kewo fe neke judgment sandene numwe esumo wa. So he's watching. So clearly, Obana Ganomie, J. Manche, J. Niadoto Tinto, G. Manche, 1990, J. Manche. Now, Wabotiami, judgment. Because this case has had a checkered history. It is 24 years old. So before now, past judgment in 2014, case in 24 years. It all began on the 20th day of June 1990, when the first plaintiff, Professor Seth Ankra, ni Onaejeme, as then the only plaintiff, commenced this action at the circuit court against the first defendant only. So now get sanite watch ajabe niji first defendant watch Seth Ankra lepeji moni eketi. In the course of the proceedings, the other defendants were joined at various stages as second and third co-defendants. So biamini case ya no ni wache adowa lefio ne no na ne imbuche gbe eba fitai na ni akwesi anyanko no na leun eba fitai. I inherited this suit when hearing had not commenced by a transfer order of the Chief Justice signed on the 10th day of June 2013. So what Mrs. Judge Neni Etane no ekeba 2013 the Chief Justice at the time case bahale ake etano. This case was entirely transferred from the circuit court to the Land/Financial Division of the High Court and same place before me to be dealt with on a day-to-day basis according to law. No, echono gwage no mie shishije case akete circuit court ni Chief Justice transfer from the circuit court keba Land/Financial Division of the High Court. Konile etasanie no ni eyesanie. The original suit number of 6CL/92/90 before the circuit court was thus changed to TRLD 45/10. No, akeni a transfer case from the circuit court number case number ni a generate a circuit court ni akeba land division of the High Court case number chake ni ebafe TRLD 4510. Now, the original parties, apart from the first plaintiff, passed away before the commencement of hearing. So onuni watch Seth Ankra no nkani abwe meni me chose meni me jeshina me chose onake no ene confirm me. The suit suffered an interminable number of adjournments. Some of the adjournments were unavoidable as the ill health and subsequent demise of counsel for the plaintiffs, the late Roland Agbozo, as well as some of the parties to the action. So onake case seche jeje nchono kwake nibi komeni ani case seche enye efe noko ye ni je mokomoko fort ni because cheme ni yo case mi ameti ami pie ela momo ame ni agbene we watch Seth Ankra at the time lewu a lawyer chon ese ona boni ni yo so nefe na kan esani achiato as well as some of the parties to the action. However, most of these adjournments could have been avoided if the parties and their counsel had been assiduous. So again chono kwake neke sanene echemo ne ni me gbogbo me chonwa me say she no we esa na echo neke chon kaji lawyer fo ni nye neke sanji ne amefe amenibi ojogban nya wo cha no. I must, however, commend the present counsel for the parties for showing such seriousness towards the prosecution of this action. As stated supra, on the 20th day of June 1990, the plaintiff issued a writ of summons accompanied with a statement of claim against only the first defendant, claiming the following reliefs. So, now, 20th day of June 1990, what I said, Ankra, legit the first plaintiff, le Jimoni eke lawsuit neighbor against a first defendant, Niji wache ajabene with the following statement of claim. Minijinoni ekeba ake kote akwe ni kote ayue ehale. Eke declaration of title ni chwake a declare ake nakanshikponje ni yo demefe be Abola Piam mbie amameno recovery of possession. Kaji moko ejushi ni eba hon eko shikpon eko ehamokwe aye nakaino na ke ame Abola Piam mbie jaka amamenini. C. Damages for trespass. Mokonwe ba shikpono ni eba fite ni bi ye shikpono ne sa na fitio na kamo abole nyomo ye no we perpetual injunction to restrain the defendant, his workmen, agents, and assigns from entering upon the land in dispute or in any way interfering with the plaintiff's enjoyment of the land, particularly described in the statement of claim. No de ka fita ye unjake wache ajabene mind you biamina je ne ke case ne wache ajabene pe akete jeje u banile stopule echilebe akeshikpon le ekaya no don enichelo akaya shikpon no don mo fe mo ni dumo enajia na ka mo le u ekaya shikpon no don jeje a stopule kula ake ekacho shikpon no kehu. Now, the first defendant entered appearance through his solicitor and filed his defense and counterclaim to the plaintiff's action. So le Mr. Jabene le eke lawyer ba ni a lawyer le ba file amesani ameka me counterclaim ba upon an application for joinder by the plaintiff. One Michael Agbewalefio was on the 15th day of March 1991 joined to the action as first co-defendant. So the second one, second defendant, Niji Michael Agbewalefio, le 15th day of March 1991, a filing for joinder ni akele afita neke sanene ni ayohi no ne woni Mr. Agbewalefio e fita a file for joinder na akele afita here abake wofe na tui on the 30th of July 1991 ni late Kwashi Ahiaku the fourth, ni late Kwashi Ahiaku the fourth, who was the chief of Kwashiman, was joined to the suit as second co-defendant. So Kwashima Manche ni actually ni late Ahiaku niji edwe lewu eba file for joinder 30th of July 1991 ni akelewu fitai. The Kwashiman stool is the immediate grantor of the first co-defendant. So ona akeshi first co-defendant niji Michael Agbewalefio Kwashima Manche eba fota neke suit nei because le on shipon eko yejeme Michael Agbewalefio no lewu eba fita lawsuit as the second co-defendant. Now nyani wayano again on the 13th day of September 1991, one Matthew Adote Alote was also joined in this action as a co-plaintiff. So once again, he was a joint head of the Abola Piam Tumawe family of Abola Piam. Right. So my conjecture was wrong. Watch Mike Matthew Adote Alote ne leon ebafita case ebafita watch set ankrai ni ebafita koni ame kenekeno kone ayano on behalf of Abola Piami. So jele ke Sempe no ba mi ona ke Kwashima Manche ba mi. So that is why obana Sempe link through nakaino. He joined the action upon the authority and consent of Ni Tete Doe Ade, the other joint head of the said family. The Abola Piam Tumawe family of the Abola Piam Tumawe family of Accra is the grantor of the plaintiff. So actually wekune wache said Ankra edumo Abola Piami be anajem. All these applicants for joinder were made under old rules, i.e. Supreme Court Civil Procedure Rules 1954 LN 140A. In this judgment, the parties would be referred to either as the first or second plaintiff or first, second, third, or fourth defendant, as the case may be. Now, it is important to state that an application for interim injunction filed by the first defendant, Kisford Judgement, on the 18th of July 1990 was dismissed by the court on the 25th day of February 1991. So, Achonogwake, neke wache first defendant neni actually Kisford Judgement 18th of July 1990 a file for an interim injunction in Nakaino court there wo a chafun 25th day of February 1991 with the caveat that but by virtue of his lordship the Chief Justice Circular number GJ/4/VOL.3/26 dated February 11, 1987. In ground of interim injunction by the courts, the parties are warned as from today that any party who goes ahead and develops the land in dispute will do so at his own risk, and that should any part ignore the warning and then lose his case at the end of the trial, that party would also lose any development carried out at his risk. So, Judge Nchono Kwake, no de wani awu achafon akko to neke Supreme Court law ne that Chief Justice said Mlako ni ekeba ake in 1987 ake keji Saneko Yano ni aye Saneko court to moko agafe noko yeno dani ababo interim injunction basana fe shwake ofeko noko yeno because kejo fe no koye no na ye sane e shibue oba lose no fe no. So clearly you can tell like a dismiss the interim injunction because what your kids for the Jaben at the time clearly fe no koye shikon which go against neke secular ni Chief Justice keba in 1987 they were a grantee na kind interim injunction ni esike. I'm going to by another notion on notice for interim injunction filed by the plaintiff. The same court differently constituted on the 10th day of May 1994 granted an order for interim injunction and restrained the first defendant, his agents, assigns, workers, privies from developing the land in dispute pending the final determination of the suit. She nomino in 1994 what Seth Ankra filed an interim injunction against many akame yesanene fe le no le kote hale noni itawo ni. I injunct all of these people from moving ahead and doing anything on the land. Thus, from the onset and by virtue of the Chief Justice's circular cited in the court's order of 18 July 1990 dismissing the application for interim injunction, the parties knew or ought to know the consequences of their actions or inactions or of any developments undertaken on the land in dispute at the end of the trial or when judgment is pronounced. On the 28th day of January 1993, the co-plaintiff died and it was substituted by Colonel J.T. Addy as the head of family. So onake co-plaintiff energy wache Michael Adote Alote Ego ni wache JT Ade but domo inajam. Now, upon an application filed by counsel for the defendants, the Sempe stool was on the 11th day of December 2006 joined to the suit as a co-defendant. So Sempe Leon ba join neke case in 2006. So biamina jenshie Sempe bemi. But in 2006 Sempe ba file for joinder. Nini ame ba file a grant ame na ani Sempe se ba fitai. And on the 11th, the Sempe stood thereafter filed a statement of defense on the 13th day of February 2007. So Sempe se lewe ni ame fe na kae ame statement of defense. But however, upon an application by the plaintiff, the said statement of defense was struck out as improper. The reason being that after the grant of the application for joinder, the pursuant order and the processes were not served on the parties in accordance with the provisions of the rules. So I don't know what I said. Maybe I'm a file. I'm a statement of claim now. Make a bad. Abola Piam be a file motion against Nakaino. Ni Nakaino a strike. I'm a no out. Because Abola Piam be a ni I'm a file. I'm a statement of claim. I'm a lawyer say serve. I'm a banner. So I'm a statement of claim. Nakaba. The service of the order and the process could have afforded the plaintiff the opportunity to amend the writ of summons to reflect the joinder. The court therefore, per its ruling delivered on the 4th day of September 2007, held the said statement of defense of the Sempe stool to be invalid. So again, yes, I want ni a chaff in 2007. Sempe be a statement of claim because it's an I serve plaintiff say. Konika plaintiff say yeah no ko yue money ameke ba fita ame sane here allo ame ni bi komena me ba chake yeah ame sane here ni amenye ni ame chake shi ame fe na kan we wo awono ache afum. Eventually, the Sempe stool filed its amended defense and counterclaim on the 3rd day of November 2010, pursuant to an order of the court dated 1st day of November 2010. No same in 2010, so from 2007, Sempe me yabu ame na I could say 3 whole years. It's ridiculous. Ni Sempe me sa a file, I'm a statement, I'm a counterclaim, I'm a defense keba. Ni ahe abomi 1st day of November 2010. Excuse me. Now I am. Upon the demise of the second defendant, Ni Late Kwashi Anyaku IV, no effort was made to substitute him. His name was therefore struck off the suit. So achono wakesane ne ya no ni Kwashima manche egbo ni Kwashima manche egbo ajie egbe ye neke lawsuit name because moko eba ke eba domo inajiami. Don happy Mother's Day to Man Beatrice. Te oyote. Shout outs to you, Dave Eason. Oyiwala don ake oba fetaway. Now, the suit was tried on the basis of amended pleadings. So, Bolenjo Banake, ni Sempe meke ame no ba ka me contact claim ba Abola Piam bi e bole amend nibi efe Sempe me, you know how it goes in the court, right? So afen na kafen so court jeje ke based on the ke chake mo ina efe ni ba nibi ni wa yesane ye none nya wakwa again the plaintiff Niji Abola Piam initially took out summons for direction. Now application for direction on the 10th September 1990. When the first defendant was the only defendant in the suit. The issues set down in the summons were as between the plaintiff and the defendant, who has a better title to the land. So I go 1990 bi amini watch Seth Ankra keneke sanine te nibi ne keteni ayejiake between le ke watch ajabe namoni a better title to Nakanshipon. B, whether or not the High Court ever made any decision that it is only Ni and Yaku who could alienate the land in dispute. Ake ani High Court ewe ake wache ahiaku niji kwashima manche at the time lepeji mokoni yo iwale ni ebanye ni ekeshipon eko aha lo. C, whether the defendant has trespassed on the plaintiff land. Agbene court akwake ani wache ajabene ekeshipon kono ni esani eyanolo. D, whether the plaintiff is entitled to the reliefs he claimed. Agbene wakwake ani Abola Piam bi ani wache set ankra duma menajia ani nibi ni amebio ake kote eha me ani nakano esa amelo. E, whether the defendant is entitled to his counterclaim. Agbene kote wakwake ani keji no ni Abola Piam bi etawo esa ani akeba ha me ani wache ajabe ani no ni lewe bio ebe esani kote kele no ehalelo. Now, upon the joinder of the other defendants and the filing of further pleadings, the plaintiff sought leave of the court on 30th July 2009 for further directions and set down the following as additional to the issue set down originally on 10th September 1990 for determination. So, Akani Agbene, Mr. Jabempe, Shimon, wache kwashima manche bafitai Mr. Awala Defio bafitai na Agbene Sempe sehu e bafitai Abola Piam bi ame chake ame amend ame nibi efe ame pleading say efe na amekeba ni ameke kote akwe neke nibi na emo ame instead of boni amekeba kenklen because bi ame na amekeba kenklen ameke Mr. Jabempe shi bi ane meni ameke no me efe edwe. I, whether or not the land, the subject matter of the dispute is at Sowutuom or at Kwashiman, as the defendants claim. JJ akwe ni eye ake neke shikpon sandene na yo ani shikpon eye ekoni achole Sowutuom alo shikpon ye eni waleni achole Kwashima noji nin kenkleni Agbene Abola Piam bi entawo ni akwe ake shikpon na yo sandene ani shikpon eye eni achole me ake Sowutuom alo eye man ni achoje me ake Kwashima tomoboni defendant say call. Number 2, whether the land, the subject matter of the dispute forms part of Kwashima lands, and if so, whether or not the Sempe stool are the allodial owners of Kwashima lands. So amesumoni akwanwake neke shikpon sanene ni ayone ani shikpon sanene efita eni wachoje me ake Kwashima lo. Ni keji efita Kwashiman shikpon here and Kwashiman shikpon here Sempe ma no ni lo nakanjino ni Abola Piam bi amentawo ni abi ehame no ni jetem whether or not by the judgment in the case of civil appeal number 30/68 entitled Ni Yaw Duade Crab neke Yaw Duade Crab ne boli anytime no ba na Sempe ma sane obana ni abakoti Yaudwade crab ke J.A. Obana yemi neke case ne ikaneko so fa nkaneko Sempe ma shikon sani ni akotiko neke case ne dan onaga ke ebale shikon sani ye wogankokpa no neke Yaudwade crab ke J.A. case ne ayuso wadenche in line with Akolache decision say Akolache decision in line with nakai no so about pay attention but like anytime what can no go between Sempe and some other stool say onake neke yaudwade crab case ne ayuso no as reference why no ni what channel eke and others, and others, the Sempe stool, the defendants and co-defendants are stopped per rim judicata from claiming title to any land lying to the north or right-hand side of the Winneba Road. So I mean, chono kwake ani neke yaudwade crab ke J.A. Quay's name, J.A. Quay case name, J.J. akwake neke sanene ni ayene ani. Emu Sempe shikponji asanji fe ana ni eka the north right hand side of the Winneba road there low emu fe na ke onani ake res judicata ni odane the res judicata me same thing and in like I know stop Sempe me ake ke ebala me shikponji fe ne your north right hand side of the Winneba road there neke sanene chona no amenye ye shikon sande kodon ye neke shikon gieno ni eyo apart from the right hand side of the Winneba Road ame Abola Piam bi enkeje jake ekwa ke neke sande na ye and stop Sempe bi yake shikon ni e go beyond the not right hand side of the Winneba Road there Sempe menye ame claim aka ma me no ona body ni eyo because na ken sande emuna ona neke ya odwade crab case emu Sempe ma shikon sanjiana no esani agmo amebe ni ame yo shikon ko sande don outside of neke noni ame describe ye BNM and of course the lawyers are watching if I'm wrong amebani wale whether or not the confirmatory purchase by indenture dated 13th June 2002 executed between the Sempe stool and the defendants during the pendency of this action is void ab initio. Agbenenwe JJ akwake ani indenture ni Sempe stool ke ha me kome in 2002 biamini aye nakansane ani nakaindenture le akakwa kla polo ab initio kake ab initio from the very get go from the very beginning ni twage ni akakwa kla po aka trying me po na aka akwe because aye sane court ya na kan shipon ni Sempe me amefe indenture amuko no Abola Piam bi eke na jeje akwa aka na kan indenture le esa na kan me ko po because na kan indenture le esa na buo kla from the very get go esa na yo awo min kla. Whether or not the plaintiff is entitled to his claim against the co-defendant, agbene jeje akwe ake ani ni bi ni am Abola Piam bi e bio esio me ni ameke yo sanene ani esa ake jeje afe ehamolo. Number 5, any other issues arising from the pleadings agbene bi ameni sane ya no fe no le jeje e ba kwe ni e ba sumo ake kefitaye e ba nyewuni e kefitaye. Subsequently, on the 3rd day of November 2011, the defendant also filed the following as additional issues for determination. Achono gwake 13th day of November 2011. So neke biamia agbene ni adote otinto eba chomanche agbene. So it didn't start from him. Eje ni adote ni alote obuo ni wache ni adote otinto eba chano. So neke case ne le agbene 2011 no mi le yemi agbene. Many junoni ame defendant say be ake hame. Ame kejeji akwake whether or not having regard to the High Court case Peter D. Quarty and 2 others versus Nilate Kwashi Anyaku the 4th. Now, mind you, Nilate Kwashi Anyaku Leji Kwashima Manche. And another suit number 114/1982 and order that the Kwashiman Manche was the de facto Manche and at the prima facie right to make grants of Kwashima lands. It stops the Abola Piam family from now making claims when they stood by when the litigation of that over the ownership of Kwashima lands raged. Okay, once again, le wache ni ahiakune ni late ahiakune ji enumone eke sanekote nche ehabo elia ni be aye ehale ake be leji ake ni leji kwashima manche shikpoji ni ko kwashima efe leji moni eyo ewale neke neke shikpoji ne baha ni keji aye na kansane hale ani nakano stopper nakano echio Abola Piam bi egbe ake amenye ni shikponko ni efita kwashima shikpon here ameke ame awomi na ameka ake amame no amenya ame claim because wache late kwashini je numo eye saniko ni nakansane echio ake lele leji kwashima manche ni kwashima shikpoji nfe ye shishi so no hale the primary fashion right kake primary fashion mi echombo primary fashion on the surface of the evidence without necessarily going into details. Dane, if you're a simple example in Abuja, Mokoba, Mote police station, Moke, Akuche, Ekbe, right? Lelen, Keji police, Kwe, Etwe, Nake, Niji Max, Yageme. That is the primary fashion case right there. On the surface of it, without going into the necessary details, on the surface of it, any proof police knew lele ashimashine wabi ekada ekadi etue no lele ke agbe etue akadi etue. Now, as to whether akuche ni gbe etue no akabaya court na yakwake ani akuche egba etue lele lo alo mo conclude ni gbe etue. So primary facie simply means on the surface of the evidence, like you just look at it and see a crime has been committed. Alo lele nekegbomo no you are no quality. So ameka jeje ekwe neke sanene ni aye ni amekwa ake ani no ha just by looking at that judgment on the surface of it, just looking at it no ni echon ake lele kwashima shipon kwashima mancheshiye yo ni le eyo egbe ni ebanye ni Number two, whether or not the statutory declaration dated 24th March 1969, registered as number 1529/69, was fraudulently obtained. So, 24th March 1969 registration, Kenya baka ye mina chole asone ame make a case bi ame no wakani ame no ake neke registration Abola Piam bi ame acquire neke registration fraudulently. Minwa asane bi you naka asane bi ke ni Abola bi apply one ameke wo paper say me ame inform me nika moko ye no ko yuemo ehimo na ba yu eshi na aha me le hu ame publish publish ni me hu ba na konike me ye challenge mo ni ame ba challenge, but of course ni wabote na kan sanjie mi ona ke no ni asane me UF jeje ke no na me UJ na kan Abola Piam bi efe na kan before na me ba register spon ame fe a public declaration ye daily graphic ni ame na registration ele hu ame publish le hu in the daily graphic ni me akane so na ke sempe me hu ye bi ame challenge na kan registration ne cover neke shikojine no. Now these were the issues eventually set down for determination. So jeke neke sanjine no na ninkane no jino ni wabaya no ni wabaye na kansane nya waya no. Again, the standard of proof in land disputes and indeed in all civil cases is proof by preponderance of probabilities. So because it is a civil case, in Kabwake, there are two types of litigation. You have the civil litigation and criminal litigation. Nifeko a standard of proof. Now, criminal litigation, no, a standard of proof is beyond reasonable doubt. No, it's any more approved beyond reasonable doubt if it is criminal. Now, if it is civil, no, a standard now use so it is based on the preponderance of probabilities. Bona, allow me go back like a preponderance of the evidence. Ni achon. So abakwe ni ka akwesa ni ake you understand what I'm saying? Ake jomobato ni abakwe ake oh so no ke ba neke you must not prove beyond reasonable doubt. Bona. So ke ebale civil cases say threshold there a lower. she get about a criminal case. He say threshold there, you're very high. You have to prove your case beyond reasonable doubt. That is why a lot of people, I'm not good lawyers, say they get away with a lot of things. You understand what I'm saying? But in civil cases, say standard there are very low. Prove case. It's just on the preponderance of probabilities or on the preponderance of the evidence. So it's not a high standard. There will be case civil cases by no I find him because boli no but the standards are different. Now, what about you can see sections 11.4 and 12 of the Evidence Act 1975, Act 323. The present state of the law with regards to the standard of proof required of a party in title cases involves a consideration or evaluation of the relative merits of the rival claims based on the preponderance of probabilities. To the extent that the parties aver by their pleadings positive facts in support of their rival claims for declaration of title to the land in dispute, they bear the burden to adduce credible, admissible, and sufficient evidence to establish those facts and to convince the court that the existence of those facts are more probable than their non-existence. You understand what I'm saying? So, look, because I use standard there to in civil cases say but party say it's any ametron. You understand what I'm saying? Once again, this is not reasonable, beyond reasonable doubt. You should be able to tell noni okeba ni okoba push your sanye ni jeje ba here womi ake ye aboe esani oni etron osani oni na kan no atron ake no you are credible, admissible, ni sufficient to ni no efe opponent no ke peli oni ye ni twa ke ko opponent ke lenwe sane ba bomoni oba win ye ne ke cases na mi esani akọ sane na na ke odabi bo sane echi fe opponent sane ne ke ba bo oni bi no ke ba o documents o wo jinke ni bi fe no ke ba ke wo kwano won na ke odabi bo sane yemi fe opponent no ne ke ba. Criminal cases say the prosecution must prove beyond reasonable doubt. The burden of proof lies on the prosecution. Keji ebale criminal cases. But in civil cases, the standard is different. So especially when it comes to land litigation. No junoni jeje egblami ehawo. Now, jeje ekebwake ekesi sewa versus kese 1960 Ghana Law Review 227 at 229. Odamete versus Clouch 1989 to 1990. Number 1 Ghana Law Review 14 Supreme Court, and Odoko versus Amate 1992 to 1993. Ghana Law Review 57 Supreme Court, where the proper preview of the burden of proof was exhaustively examined and put in its truer perspective by from Benjamin, Justice of the Supreme Court. So ahabo authority ni wakwe ni ayesane koneke ni akwe boni esane ayeneke sane. In the case of in RE, if I get look be near Kweche be Ashaleboche lands, Ajete Agbosu and others versus Kote and others 2003 to 2004. Supreme Court Ghana Law Review 420. Justice Brobe, Justice of the Supreme Court, explained the relevant provisions of the Evidence Act at page 464 and 465. Thus, the effect of sections 11.1 and 14 and similar sections in the Evidence Decree 1975 may be described as follows. A litigant who is a defendant in a civil case does not need to prove anything. The plaintiff who took the defendant has to prove what he claims he is entitled to from the defendant. So Justice Brobe Sanene once again, it put the onus on the plaintiff. Keji ebale shikon sanjineke ake defendant tele akele ba prove inoku. Shile plaintiff ele monde ke sane te the onus is on le ni eba prove ake sane yemi no one ke sane ba ubaka ake. It is akin to criminal prosecution where any the burden of proof is on the prosecution. In criminal cases, the burden of proof earlier is on the prosecution. And then by the same thing. Okay, in this case, plaintiff legit prosecution. Of course, the defendants are the defendants. No, any justice brobe here. The onus is on the plaintiff. Le moneke sani ba kone prove ake lele neke shikone ni ayo le enomi. At the same time, if the court has to make a determination of a factor of an issue, and that determination depends on evaluation of facts and evidence, the defendant must realize that the determination cannot be made on nothing. If the defendant desires the determination to be made in his favor, then he has the duty to help his own case or cause by adducing before the court such facts or evidence that would induce the determination to be made in his favor. Justice Bobena can send me no Shimon Kennedy come ni esania kwe ni le defendant feel like she kaji akwa na kan no ebawale benwe lewu eken no ake le ba je na kan ni epo le ken na kan ni bi e baba ni bi ni le feel ake kaji court to ekwe lewu ebawe esane enye tashi ni taflache again na jimbawe lagbam ne ba ka ke the burden is on the plaintiff ni eba adduce evidence to their favor. She le defendant tell lewu kaji feel like eye ni bi kome ni eba nye keba ni eba we sane le defendant tell lewu sane nye je na kan ni bi ekpo ona boni ni yo ni ewale ekatashi ne feel like be court to ba yue na kan no ehale. However, it must be emphasized that the burden of producing evidence is not fixed. So once again, face no ni we ake plaintiff Justice Brobeke is any plaintiff afi ni defendant one fe ke bale sanjin kome to moneke neke no kone afixiko ni chwake in an explanation of the relevant provisions of the Evidence Act, Brobe Justice, as it then was explained in the case of Yokwa versus Dua, 1992 to 93, Ghana Bar Review 278 at 282, that however, the evidence degree makes provision for the duty of obligation to adduce evidence to shift from one party to the other. In a situation, the duty or obligation could shift from the plaintiff to the defendant. So a court another authority go. Justice Brobe it is not fixed. It is not set in stone. A court another authority go evidence mean abanya shift from one person to the other. Abanya kake bo defendant bo prove mo sande. Abanya kake bo plaintiff bo prove mo sande. It is not set in stone. It is not fixed. If and when it is shifted, the defendant will be required to lead evidence to establish the sale once he claimed to have possessed by reason of sale of the house to him. So I don't know why neke evidence ne e balake is na shifted na shift from the plaintiff to the defense. But defense is an no newo ni nakaino le no ni neke shikon ne neke shia ne na you le no ni newo isani aye sane ehale. When the duty or obligation to adduce evidence shifts and the defendant fails to adduce evidence or any evidence on the sale, the ruling of the court on the sale will be against the defendant. This is the reason for the provision in Section 14 of the Evidence Act, Act 323, which states, except as otherwise provided by law, unless and until it is shifted, a party has the burden or persuasion as to each fact, the existence or non-existence of which is essential to the claim or defense is asserting. So, that unless the judge by touching about question them now about shift defense, Benuele is on you, depending on whatever the case is. The Supreme Court further explained the point in the case of Ajete Agbosu and others versus Ebenezer Nikwe Kote and others, 2003 to 2005. Number 1, Ghana Law Review 685 at 710. That now it is trite learning that by the statutory provisions of the Evidence Act 1975, NRCD 323, The burden of producing evidence in any given case is not fixed, but shifts from party to party at various stages of the trial, depending on the issues asserted or denied or both. It is right. A machine. Naka no a machine. Mo friend mo enushishi. One nushishi mla ane one nushishi. Keji e bale ke okwe evidence decree act in 1975. Look, the burden of producing evidence in any given case is not fixed. It is Strides law. Accept money. You're responsible for proving evidence. Shift from one party to the other, depending on Sunday. No, about you. Now, counterclaim. It must be remembered that the first defendant in his statement of defense also counterclaimed against the plaintiffs. Per his process entitled statement of defense filed on the 4th day of March 2003, the first defendant counterclaimed per paragraph 15 thereof as follows. So, Mr. Jabene, leun a counterclaim ni ekeba eshi Abola Piam we no jino ni akeba. That the defendants claim against the plaintiff and Amate killer jointly and severally. Who is Amate killer? Okay, so defendant said. A counterclaim ni ekeba against first defendant defendant from so the defendants claim against the plaintiff and Amate killer jointly and severally. Defendant say counterclaim declaration of title to all the piece or parcel of land situate and lying at Kwashima / Sowutuom, Accra, and containing an approximate area of 0.44 acre, bounded on the northeast by a proposed road measuring 134 feet 9 inches, on the southeast by stool land measuring 168 feet 8 inches, on the southwest by stool land measuring 101 feet 9 inches, on the northwest by proposed road measuring 162 feet 8 inches, more particularly delineated on a plan attached here to and thereon shown edged pink. So I mean what make nekeshipone ni akọ ayuosane ne akwe ni adeclare na kan shipon kana kan shipo jine bolele fe ni akwa ke ani na kan no Kwashima na kan shipo jine e Kwashima ka Sowutuom boundary na kan shipon jame adeclare title e ha me akebe ame amame no ni defendant say fe. Now, damage for trespass. I damages against Abola Piam be special damage of 459,000 cedis. Now, me be special damage of almost 500,000 459,000 cedis. Perpetual injunction against the plaintiff alone. I injunct plaintiff ni ekaba shipodon. Damages for causing the first defendant's unlawful arrest and detention. Nichwake obana kebe Abola Piam be amehani amo neke wache minijegbe ajabene leji first defendant ni jeje ahe damages against Abola Piam be kamomo ni amehani amo first defendant niji Mr. Ajabene. Now second defendant ueba second defendant, mind you, Leji Agbawale Fiowe. The second defendant filed a defense and counterclaim pursuant to an order. So first one was the first defendant. Dated the 24th day of May 2012, on the 30th day of May 2012, in it, he counterclaimed as follows. Declaration of title to all that piece of parcel of land described as Sowutuom. So let counterclaim any ikeba. Shout out to you. Miriam, yeah, you can hear me. Happy Mother's Day. Happy Mother's Day to you, Miriam. So, second defendant, Mr. Adewale Fiowe, baby, Adewale Fio, but I know it ends with Lefio. So, Leweke, Akake, Shikoji declaration to title to all the piece or parcel of land described as Sowutuom. The second defendant, Leleke, Shikon fe na chole Sowutuom le ake title le ehale le Shikon sometimes described as Kwashima, bounded on the northeast by stool lands measuring 10 feet / 9 inches on the south. So each on the specific part of Sowutuom ni eke kwashima na husue eke neke shikpon ne na kanjame achoje me Sowutuom shimo eke kwashima na husue a declare ke na kan shikpon fe le Mr. Adewale Fio le noni chombo inchi se boni shikpon daleyo perpetual injunction restraining the plaintiff and the co-plaintiff, their agents, servants, assigns from interfering with the enjoyment of the second defendant. Ni once again, court again in the afo watch Seth Ankra ke watch Yayadi ni at this time amenyo G plaintiff say agbenem ni ameka ya shikpon no don ameka chu amenuchulo ekete shikpon no don ameka chu amewebi ekete shikpon no don ni amengme le second defendant tegbe ni enjoy le dienche shikpon recovery of possession I shikpon hale agbenenwe damages for trespass akeni shikpon ama menoni ni Abola Piam bi eba shikpon no I damages against amehu be cost per each further amended state of defense and counterclaim filed pursuant to the order of the court of the 16th day of October 2012, the Sempe 2 also counterclaimed as follows. So, agbere Sempe mehu, Sempe sehu ni amebafita neke lawsuit ye. Ame omeni jinoni ameke jeje ayue eha ame. Nyani wabote ami. The whistle is in the building. Shout outs to you, Mr. Ankra. Shout outs to you, Man Grace. Auntie Toyote. Shout outs to you, Atoka Ankpa, Impa, Ofane Bebo, Oye, Ojogbam. Now, me jinoni Sempe me. Akujage Anagojo is fighting gallant. Kwe, Lulumenta International. Akuje, bele ahoy hale, game ahoy hale. Bon, so it's okay. Ganyo kwe on shikwe hale. Ni mogweba kempele bagele noni. Akujage Lulumenta International. Ora, alu ocho lumona alu international. Oh my goodness. I go check Lumo, international Lumo. Anyways, so many don't Sempe make Sempe make a declaration that the statutory declaration by the Abola Piam registered as 1529-1969 was fraudulently obtained. So once again, Sempe made the same case. Ni asreme make Sempe make the same case. 2012. Okay, so no me ayeko na kansani. So I'm sure they didn't know. But I don't know if their lawyers actually did their work. Onake ni Abola Piam be ka sene ma sande. Jeje ejebe a lambast asreme wa when it comes to this registration. No kwe. Jeje come ake I'm a due diligence. Ke I'm a due diligence ojuba. Amekeneke noko ba ake registration Abola Piam be fair. They did it fraudulently. Clearly on ake Sempe me where you can tell ake I'm a make investigations so the and other excuse me and other canceling the said statutory declaration registered by the Abola Piam Sempe me not only judge ame ne kama ake ame ne yu ake I'm a register nekeshipone fraudulently agbene nakano afomi a declaration that all those land described as Sowutuom so nyebuatwe this is where this all Sowutuom onake noni Sempe me kabane mind you no me aye shipon komeni ahonho ya nekegbemene but Sempe me ne ameba look at what they introduced to the whole thing yebie all a declaration that all those lands described as Sowutuom have always been and still remain the bona fide lands of the Sempe 2. So Sempe na meba J tumobono na second defendant on second defendant any Mr. Adewale Fio and aho shikwen ale ye a border it's a what like it's a border minimum border town right between Sempe between Sowutuom ke Kwashiman, right? For lack of a better description there. Ele ene shipon yo a border town me. Ona so onage ekake a declare ke any le shipon yo no kwashimambia no because kwashimambia lo Sempe me jimeni wo ehale she call question Sempe ma no Sempe me ame counter claim na me ke ba me ke adeclare ke Sowutuom shiko jien fe ke blema ame Sempe ama me shiko ji Sowutuom shiko jien fe na ka no ni Sempe me ke tumoboni nkan ya bo a declaration that all those lands described as Sowutuom have always been and still remain the bona fide lands of the Sempe stool. So, nonime ni Sempe biye kebane. No, the final one. Ne a declare amake Sowutuom shikon GFN ama menoni. So, let's go on. Let's see what will happen. Now, to the extent that the defendants counterclaimed against the plaintiffs, they carried an equal burden as the plaintiffs. I love reading this because seriously. I go law school and I regret for not doing so. But reading this statement say BP. So Keji Obakane Benny JJ describe money, the burden of proof is upon Obanage I describe now abo instances. Nike ayesani ne baleneke be ebanye aneke no ona oliake a portion koni was share you ake it is straight law ake keji ebaleneke majiansane money honor the burden of proof is not fixed, it is not set in stone based on sane boni ayo like nibi na ayo ebanye shift from one party to the other. So be an jeje e kewake akeni defendant say I'm a counter claim, then they also carry an equal burden. So now the burden of proof is not only on the plaintiffs, but it's on the defendants as well. Because I'm a counter claim, they are also asking for the court to award certain things in their favor. No, the burden of proof they equally carry that. Another authority could be. In the case of Jasco Limited and another versus Apau and another 2209 Supreme Court Ghana Law Review 263 at 270. The Supreme Court per Justice Doche commenting on the burden of proof where a defendant also counterclaims stated, we wish to observe that the burden of proof is always put on the plaintiff to satisfy the court on a balance of probabilities in cases like this. Thus, where in a situation the defendant has not counterclaimed and the plaintiff has not been able to make out a sufficient case against the defendant, then the plaintiff's claim be dismissed. So, Justice Doche ni eye neke sandene. You know what? Well, you know what are some of the finest justices? Look, their politics you may not like, but Okane Justice Doche Enibi Sanjine no Justice Brobe Atugu Tubigame Justice Alpaume ke Okane look I may shape what judiciary in the 21st century very well. I may nibi ni Sanjini ametano ye Supreme Court I may shape the way ni. And I think it's going to be for a while before Nibi Kome Bachake, just Oche Atuguba, Oche Justice Apa, Oche Justice Brobe, Oche Justice Doche. These men and I'm a squad there. I may shape what jurisprudence Ojoba Dienche, especially in this current dispensation. They've done a formidable job. How much I get when they choose to be just. Because I'm a Sanjin, pretty much, quick cases now. Your neke biamine fe onake akota me wa denche, akota me wa denche. Okay, so let's go on. So Justice Docheke now, yes, court take a burden of proof. Monique Sanie bano nile echon no de wani aye Sanie ehale keji defendante. Niji monaka sani beshi le e counterclaim. But shout outs to you, Man Rose. Man Rose, happy Mother's Day to you, Man Rose. Ofane boy ojugba. keji e counterclaim me kemo kesane ba ni defendant e counterclaim me no ele the burden of proof court e ba shi e plaintiff le mo ne kesane ba koni e prove na kaino ni we ni enye prove be abaye sane e shile na kanjino ni Justice Doche Yue ye case na ni aside name. Continuing at page 271, the court held thus, whenever a defendant also files a counterclaim, then the same standard or burden of proof would be used in evaluating and assessing the case of the defendant, just as it was used to evaluate and assess the case of the plaintiff against the defendant. So once again, it confirms some of the earlier authorities say any judges cited is pretty much reaffirming the same thing. No Justice Docheke Shimon keji defendant e ke counter claim ba benuele of course to be na kebo ke balene ke maji ansane the burden of proof is not set in stone. It could shift from one party to the other. Justice Doche Ekewo the same thing again in a case where any defendant a counter claim beleun or equal burden ni approve a case. In the instant appeal, the defendant's counterclaim, and that meant that they also assumed the position of a plaintiff in respect to their counterclaim. So judge Nchono Kwake, because Sandene na your plaintiff I make claims back. The defendant say a counterclaim. I mean esani I may prove the standard of proof eko ye ameno. I mean the burden of proof eko ye ameno. Ni esani ame proof ame case. It is against this standard of proof statutorily provided and placed on the parties that the cases of the parties will be measured. So ke boni wa no shishineke ne wa ame sanjina me baba no jiboni wa ba kwele ni wa ba ye sanie. In view of the bulk of the record, the volume of the evidence and the time lapse, it is my intention to concentrate on and evaluate to a large extent the evidence of the first plaintiff and the first defendant as the principal parties to the suit. So because of evidence na keba ne fire war masumo ni ma focus mainly on noni plaintiff keba neji Abola Piam bi ama me sane ka me ni bi na ame evidence ame wojin ke no fino na me yo na me ka fita amekwa pia amesane say because of ni wojin fa evidence fa ni baby ewo masumoni what yusu noni Abola Piam bi ekeba ke noni first defendant ekeba ni jimi say ajabe because amena me jeneke sanene shishikula dani fambi efe ba fitai. After all, the first plaintiff claims to have derived his title from the second plaintiff, whilst the first, second, and third defendants claim to derive their interest or title from the first defendant. So, Jaja Nchono Gwake, mino ma focus on first plaintiff evidence they provide, the first defendant evidence they provide in Kechuni. Ejake second plaintiff ni fitaye, ledi enche ani wana wali yake first plaintiff jimoni ale iwaleni eba fitaye. Agbeneu the second plaintiff niji adewale fio, number third niji kwashima manche alate anyaku niji enumo ke number 4 niji sempe stool neke defendants 1 2 3 ame wale ame na ke je sempe stool bona sempe stool ngo. So sempe stool even though about joint suit later jeje enye establish ake first defendant, second defendant, third defendant ame wale na ame bana ame ke yo sane ne fe ame na ke je sempe mi bona. So mako first defendant wojine keba ke nibi ne keba ne kwa support the case ni mako first plaintiff no we ni wo ba work against each other kono wa kwa ke minijinoni sane bagbe. Indeed, the second defendant claims to have initially derived his title from the first defendant. Nitwaga Mr. Adewale fiwe lele nchashishi je mie kakele wale ne nye pu first defendant nike hale. This is not to say that the pleadings and testimonies of the other parties are discounted. Jeje ke inke mako Abola Piam bi mo ni dum amenajian ke sempe stool dienche first defendant ni le we na wale ke sempe stool ke inke mako ame bojin ka ame ni bi na ame ke ba ni ke yesane no echo ake other defendant say ba me sane ikwe alo ihe awo mi alo nke ihe ya ajeme dabi jenaka. The evidence of the other parties would provide corroborative evidence for the evidence and case of the first plaintiff and the first defendant. So jaja ke no ani mi fe na kan second plaintiff anything what ya yade no fe no ne ke ba e ba pia no ni Mr. Seth Ankra ekaba ye Abola Piam na jiam agbene Sempe stool kwashima manche ke Mr. Adewale fio ame oni bi fe na me ke ba e ba pia no ni first defendant energy Mr. Ajabe nkeba bona because Mr. Ajabe like a case ba first then me name me fe ba fitai so ni no fe no na me ba it will be a corroborative evidence e ba pia ne first defendant no say and on the other side the first plaintiff e ba pia say so no etwa kekenke me use me enyo na no pe be no ni me ni fitai e ke ba nkwa ejeme alo he awo mi alo ndwen alo nkechuni. Again, by the nature of his pleadings, the first plaintiff is engaged in a contest not only with the Kwashiman stool, but also with the Sempe stool as being the alleged allodial owners of the land as far as the Kwashiman stool is concerned. So, yes, Obononi Mr. Jabeni, the first defendant, Obana gets Sunny, Abola Piam be a peke. She called me to some extent, it can send payment, le she point a Kwashimandi. So no yemi. Now let's go on. The first plaintiff. Oh, at this point, Bejang Bina, Bona, Ken Bina, yeah, Ken Buamak Bina. The first plaintiff commenced its evidence on the 2nd day of April 2012, i.e., 2020. Oh, 2nd day of April 2012, i.e., 22. Oh, excuse me. I.e., 22 years after he had commenced this action. Ni 22 years after ni ejeneke sanine shishien. Bakwak bena babo te sanye mini eke esanjie baba. Mind you, keji oba join wo later. Aje sanine shi 1990 ni aje sanine shi. According to the plaintiff, the land in dispute is located at Sowutuom in Accra. He described the land as bounded on the north by a proposed road, measuring 280 feet on the south by a proposed road, measuring 300 feet on the east by an existing road, measuring 110 feet on the west by a proposed road, measuring 120 feet and containing an approximate area of 0.76 of an acre. He stated that he acquired the land from the elders of Abola Piam Tumawe family in August 1979. At the time of the acquisition, the elders of the Abola Piam Tumawe family were the late Charles Okaimboche and the late Matthew Adote Alote. He was given an indenture and a side plan to evidence the acquisition. So, Mr. Ankra, even though Lewe said Abola Piam, Abola Piam. So that's what it is. Ni chameni o shikwe ale nojino ni echon shikwe 1979. He was given an indenture and a side plan to the evidence. The date of the indenture was 22nd August 1979. Indenture ni ekebale mwe adetile 22nd August 1979. He subsequently had his interest in the land registered at the Lands Commission with the registration number 2184/1984. So Mr. Ankra ne shipon le ni 1984 he registered shipon Lands Commission. The indenture was tendered in evidence without objection and same marked as Exhibit A and A1. So jagen chowa no kwake neke indenture ne akebako tuwe ni ana. He erected corner pillars to demarcate the boundaries on the land and occasionally had the land cleared of weeds. In 1988, he commenced construction on a third of the land. In the latter part of 1988, he noticed someone had started digging trenches on the land. So, ni a register shipon. Every now and then, ni ayahu shipon. Tumobonika wa shipon. Ni wafeko ready. Ni wahani mehu onwe hawo. Ni 1988, efe yake ekepiles mamono. Ona ekepiles mamo shipono. Shimon a boy no ko dumo fio no ko ma fio ye a third ni twagebe e jashikon mi eten ni ekomi a boy no ko fio ma ye no Shimon. Thank you Rev Rev Ebatrashi. Thank you Rev Shimon. Shimon, somewhere around 1988 enake moko leun eba ni etefe noko yeshipon. Immobilized some youth in the area and are the trenches covered. Some few weeks later, the trenches were reopened. So the enaga moko eba cha shipon. Ona boni ni yo ni ebomode ni etau oblanta ni akuchuemi ni amebachi no ni abacha ne she ochi fio ko bashwe mi enake no na abacha ne asa abacha ekom. Upon inquiries, it got to know it was the first defendant who was digging the trenches. Ni chwake ni eteni bi amie enake Mr. Jabeni the first defendant leani aba acha neke shikono ne. He therefore reported the matter to the local police who accompanied him to the land where they met the first defendant. The police arrested the first defendant. He was requested to provide his document on the land. First, the defendant intimated to the police his documents were being processed at the Lands Commission. So ni Mr. Ankra ani amo Mr. Jabe akelake eke ewoji aba ewoji ne yo shipon no ekeba onuni achono gwake Mr. Jabe nke ewoji eye Lands Commission ni achueni. And this reminds me, me Tony ma Kenya Fenake Niaye is doing okay. Niaye is doing very well. I should have started this with the show. Niaye is doing very well. Prophet Boy is in the building. So nyemeni nyelenoni teno show enonye Niaye is doing very well. Nkele eyuele bine is doing very well. And Sani Aboli akwe Ayue to some extent. She wabakwe noni ba Jamie ebawo because Ayue she agbekuna. So we'll see what's gonna happen tomorrow. Any updates in baba Mani Nyeleba Niaye is doing very well. His family, everybody is doing great. Just so you know. Yani wayano. The first defendant was advised to keep off the land since he had no registered document covering same. So police were like, look, neighbor document say according to the first plaintiff, for about 14 months, the first defendant kept away from the land. However, in or about 1989, the first defendant resurfaced and started constructing a building on the land. So onake ni police were ake yenyoji nyuma ke dresse anale shikono. She no say agbene onake ese ba shikono eko ni ebo ni bi ma alo ebo inokoma ya shikono. Whereupon the first plaintiff informed his lawyer and wrote to the first defendant requesting him to keep off the land. So ni wache Mr. Ankra na nikenoko ne maleta kia lawyer ni lawyer maleta kia Mr. Jabeng ake shikon eje shikono. The letter was tendered in evidence without objection and same marked as Exhibit B. Nekele tane ni wache Mr. Ankra a lawyer ma kia Mr. Ajabe nekele tane akenomba kote amakino as Exhibit B. The first defendant neither responded to the letter nor ceased his activities on the land. Face Mr. Ajabe ni echumo eshikono. No de ya no ne efi eshikono ete no ni efe no letter oni lawyer fu egmalele nwe efomi respondi. He therefore commenced this action against the first defendant and subsequently obtained an injunction order against the first defendant. The order was tendered in evidence without objection as Exhibit C, C1, and C2. Ubana ke ko ebi elia neke injunction ne jeje iwehe ne yawa reason e woni neke injunction ne a grantee Mr. Ankra. So anyone na wali ake no say me Mr. Ankra no honey ete no ni a file neke lawsuit ne in 1990 as far back as 1990. Once again, Koba join one fine kekemi ake owner inside ni in Facebook directly because in Facebook directly is an ima chonkwe last time an in question wa de enche So no one in face in the can. So fine, pardon me, I can in face Sibo directly in me face in the can. This morning the laptop on Baba Bia because it batching oh yeah, on a bonnie and I don't want that. The one in Kebabi and Oni Onyeni Onami. So let's go on. In the course of the suit, the plaintiff realized another portion of the land was being developed. So Mr. Ankra chono ga bia me ne gesa ne ya ne no e na ke o moko we ba ni lewu manoko eneke shipon no. Upon investigations, it got to know the first defendant had sold that portion to the developer who turned out to be the Mr. Ajabene Triye. Agesani te court. Ayesani ake injunction e mono. E che to away that. Me on shikwe ko Mr. Minije gbe Adewale fo Adefo wale Mr. Second Mr. Ajabe Esatriwa ni twanke like a contempt club anye mole pona ba wole mon cry because you've been injuncted from doing anything on the land. Ete ne on shikwe another person Niji Mr. Adewale phone shipon na bo injunction ye no I injunct wa ke kaya shipon no ya no ne ba me no nwe she ya won ko won developer. Oh my goodness. He was compelled to apply for and was granted an injunction order specifically against the second defendant. So Mr. Ankra ne she no say she esete ne injunction against defendant ni Mr. Ajaben shikwen. It was tendered without objection as Exhibit D. Ne injunction ni against the second defendant. Shout outs to Mr. Ankra. Prof. I doff my heart. I doff my heart out to you. Shout outs to you for sticking on business and going about your business. I mean, powerfully. Shout outs to you. I doff my heart out to you. No, neke evidence there, Akaba. He mentioned that another order for injunction was granted by this court, differently constituted. It tendered without objection the said injunction order as Exhibit E and E1. So Mr. Ankra is shout outs to Mr. Ankra. He did a yeoman's job in this case. Noko slightly by Now let's go on. The second plaintiff, Joseph Yaya Ade, is the current head of the Abola Piam Tumawi family, the first plaintiff's grantor. He gave evidence through his lawful attorney, Tete Churu Ade, who tendered in evidence Exhibit Z, a power of attorney executed in his favor by Joseph Yaya Ade. He testified that his family owns Sowutuom lands. According to him, the family made grants of Sowutuom lands to the Catholic Church for a seminary. Once again, what Yaya Ade ni a lawyer about tender in all of this evidence. Yake neke no kone ameka asema sane attenda neke evidence ne ke ba kote fe pepepe ameka ke Abola Piam bi amame weku shiponji Sowutuom land se ameka evidence ba ni twanke ameho ekoya Catholic Church ni amekema seminary ameka naka evidence ba. He further tendered a document evidencing another transaction between Volta River Authority Volta River Authority and the family covering another part of Sowutuom lands as Exhibit BB series. According to him, his family shares boundary with Awule Mona family of Ofanko. So I'm in trouble. I'm Abola Piam be I'm a shipon many I'm sure Wusu. He tendered in evidence a declaration of title of the said Awule Mona family as Exhibit CC series. It was part of his evidence that in 1953, the then Gold Coast government mined sand and gravels from their land. The family therefore put in a claim, and after some discussions in 1956, compensation of 80 pounds was paid to the family. So once again, I'm a shikon no ni government goes go to government here eba chashia keteye no ni ameji meni apiame compensation. He tendered in evidence without objection some correspondence relating to that payment as Exhibit DD and DD1. Once again, I tender in evidence. No phenomena you are caught to akewolo yehi. And once again, this is why I keep saying, I said the last time, look, we need to go back. Those of us that are educated, those of us need, we are of this generation. Ni be echake. Look, prophet back one che bipo one che po a four sofu one che a four sofu. I don't know. In le no ni ma fe. Prophet, you are I get one che four sofu one che a four sofu. So walk back. We need to stop it. This is what happens. Imagine when Abola Piam in BA, they didn't have somebody like Mr. Ankra. You understand what I'm saying? Get what chombo in grandma. Bonnie eke one jamo yo obabiake nimbe chon ni prophet the chon prophet. Allo wrong san in grandma le we de ko ake nyumabi kromo di abunsan. Igrama acha kekle no na ale de taye. She ebi ne kana bi ne for fen osofo ison. Wo fen osofo eji wo. Bona, she na onu na ba acha kekle ne taye. She bi ni je musumi fen wo fen osofo eji wo ebi kana bi fen osofo e. So we need to go back and help our family. We need to go back. It's only why ni wa we kume. This agbene shiandra and it is not right. Yeah, what channel? The first defendant testified through his lawful attorney and wife, Margaret Odum Ajaben. She tendered in evidence a copy of a power of attorney. Exhibit Ajaben 1. According to the attorney, she and the husband approached the chief of Kashiman for a parcel of land. So, Mr. Ajaben any the first defendant. Leo eba chon nune wani esani shipone ashia mena mema eke shipon ke enga Jimoni ba lawyer through his lawful attorney and wife. So Mr. Ajaben enga ke lawyer ni ba yodasie ake ame shipon ye kwashima manchedi lede ame shipon ye Mr. Ajaben ke nga ame shipon ye kwashima manchedi. They were taken to the land by the surveyor and elders of the chief for demarcation of the land. Surveyor kamete shipono at demarcate shipon army. They erected corner pillars to demarcate the boundaries of the land. Ama make a pillars machine. They were later given documents covering the land. Upon learning that the Kwashiman stool is a caretaker stool for the Sempe stool, they procured another indenture and a site plan from the Sempe stool. So mind you, I'm a shipon ya Kwashima manchedi. I'm a pillars emamono. She said, "Mini, I'm an ake Kwashima shipon Sempe mano ni Kwashima manche kwano ke ha Sempe me. Amete Sempeu ni Sempeu fe indenture ehame. So I'm a indenture enyo. One from Kwashima, another one from the Sempe stool. This was only after a physical inspection of the land had been undertaken by the Sempe stool. So I'm on Sempe stool ke amete shipono ni ama kwake anilele ama me shiponi lo ni ahame indenture. Now let's go on. She identified Exhibit H, which was the document on the land executed by the Kwashiman stool in their favor. She further identified, identified, I think it's a typo, identified Exhibit J, which was the document executed in their favor by the Sempe stool, represented by Ni Adote Obua the first, Sempe Manche. So, Ni Adote Obua fe indenture ehame. She gave the dimensions of the land as bounded on the north by land measuring 162 feet, on the south by land measuring 168 feet in 8 inches, on the east by land measuring 134 feet 9 inches, and on the west by land measuring 101 feet 9 inches, with a size of 0.44 of an acre. She admitted that there is a difference in the dimensions of the land as stated on Exhibits J and H. She explained that the difference was caused by the different instruments used by the surveyors of the Kwashiman and Sempe tools. She acquired the Kwashiman documents in 1988, while she acquired the Sempe documents in 2002. She stated that their documents were in the process of being registered at the Lands Registry. All these years, Kaji O documents say a through it. That should tell you something. 1988, no, ni Kwashiman BFA habo. Ni ya through. Ni 2002, no, ni Sempe me on fe habo. Aye sanene in 2010. Finally, I started sanene in 2010. Let's deal with the Sempe part from 2002. Ni okokete Lands Registry. Ni 8 years down the line. Still, anya register amboe. You should know okay, something is wrong. They engaged the services of someone to work on the land. One day, their worker informed them someone who claimed ownership of the land had destroyed the work he had done. The first defendant visited the land the following day, and he was invited to the police station by policemen who had been taken to the land by the first plaintiff. Upon request of the police, the first defendant produced his grantor together with one of his elders. When the first plaintiff could not produce his grantor, the first defendant was permitted by the police to continue with his work on the land. So testimony ni Mr. Jaben wife clearly it is against noni Mr. Ankra you Mr. Ankra chono kwake ni ekesani police station police work like because enyeko ni eba provide wolo ni ba chwa ke shipon le no ni eka chuni ye shipon no a wife and kake na get to police station a awo elders come keba ni police work ameya no ni amechuni so bona he say she say. They continued construction up to the roofing stage when their worker again reported that apart from the build part of the building had been pulled down. This took place on 3 different occasions. They therefore engaged the services of a caretaker to live on the land. They were then able to complete 3 bedrooms in the building and moved in. This was in 1990. The plaintiff was by this time working on his portion of the land. So I'm try roofing level work. Finally animoko bahi shiami shwesumami ni amekwe ni amekegbe 3-bedroom house na yejeme na kan bia me no Mr. Ankra still yano ni echu eni olo. According to the attorney, she and the husband were first on the land and were first to commence work on the land. She stated that the first plaintiff commenced construction on the land in 1990. Clearly, Obanake J Nakanji testimony in Mr. Ankra. Mr. Ankra is start doing working on the property in 1988. Meneme unchono kwake amek bi ameno na kla before 1990 ni Mr. Ankra baboy nuchumo yeshipon. She recounted the troubles they had to go through as a result of the conduct of the first plaintiff. In all, the cost of destruction to their property caused by the first plaintiff totaled 4,100 Ghana cedi. She stated that in the case of Johnny Hansen versus Ni Late Kwashi Ahiaku IV, the court made an order to the effect that it was the Kwashiman stool that has the authority to make grants to Kwashiman lands. In that case, the extent of Kwashiman lands were indicated in an attached site plan, and their land is located within that land. So, Obana keneke case ne Johnny Hansen can ni late kwashi ahiakuni je case ne a reference le earlier ni echono wa ken nakan no nakan sani na ye mi acho any kwashima shikon jie yo ni ye amesusumo mi ye shikon no ni ahon ha me ke okwa nakan judgment mi ye shikon ye kwashima anomi. Now this she denied that the land in dispute is owned by the Abola Piam family. This is because all the surrounding villages, it is the Sempe stool which installs the chiefs. There you go again with this majiachemeni awele ye eni esani awelio ye. You understand what I'm saying? So as far as now I'm concerned, shikonjie ni bole amefe sempe meji meni ewele majiacheme ye jeme fe no le here you ake neke shikon ne sempe ma noni nyawo chano. She stated categorically that the land in dispute lies between Kwashiman and Sowutuom. She described the distance between the land in dispute and Kwashiman as being 3 times a football park. The same distance is between the land in dispute and Sowutuom. So le ye susumomie le shikone here Kwashiman no mi. The distance ni yo between noni le consider Kwashiman shikon ke Sowutuom shikon edaletomo football park ete. The second defendant gave crisscross evidence on how his father acquired the land. He described the Sempe stool as the allodial owners of Kwashiman lands. Mind you, these people were all talking about Kwashiman lands. It was up until the Sempe stool now ameba introduced this whole thing of Sowutuom lands earlier on. Ken okwe Sempe me ame counterclaim ni amekeba. According to him, his father got the land from the first defendant, who then led his father to the Kwashiman Manche, who in turn granted the land to his father. He made the payment to the Kwashiman Manche. His father immediately went onto the land and fixed corner pillars. He constructed a 5-bedroom house to the lintel level. In 2001, his deceased father approached the Sempe stool, the allodial owners of all Kwashiman lands, who executed a document in favor of his father to confirm the grant made by the Kwashiman Manche. According to him, in confirming the grant, the Kwashiman Manche gave his father According to him, in confirming the grant, there should be another comma. So now comma I was so mean candidate trala. According to him, in confirming the grant made by the Kwashiman, I don't know. Let me go on. The Kwashiman Manche gave his father an indenture. He tendered a photocopy of an indenture executed in favor of his father by the Sempe stool as exhibit Agbe Walefio 1. And this reminds me of Noni Waye the last time Yabiake. Look, Nimbo in a Kenny be in a canimone. Eani in Nake. Look, Kabu indenture. Ko eshipona abo indenture kabule. Indenture means nothing. Indenture does not show title to any land. So once again, if you are watching me, especially when many were your man second be again an indenture given to you on a land ni o purchase, it means nothing. Absolutely nothing. If you do not have title, if you are unable to register the land, ni oba acquire title to the land there, the indenture means nothing. Mokobaba ni eba nye title to the land. Ni oba na go indenture no ba fe onye atoka ba ke tiafi wolo. In 2002, his father submitted his document for registration at the Lands Commission, where it was given number AR/22075/2002. He described the land as being at North Kwashiman, sometimes called Sowutuom. So nagelewu eba introduce this old Sowutuom near Keba. So the second defendant Leweba introduced Sowutuom Saniye Keba biye. He denied the claims of the Abola Piam family to the land in dispute. He referred the court to a case entitled Peter E. Quote and 2 others versus Ni Late Kwashi Anyaku the Fifth and others, where a court stated that it is only the Kwashiman Manche who has the right to alienate Kwashiman lands. Man Christie ever fit away. Man Christie Happy Mother's Day to you. Happy Mother's Day to Man Christie. As stated supra, several issues and additional issues were settled for determination. However, a perusal of the pleadings and the evidence led by the parties and their witness revealed that the pertinent issues arising out of the pleadings and the evidence for determination are one. So, Jajake, inu ni BP, ikwa wojimpi, me eba yu ni BP, me ke ni BP eba, she ken kwa miye, mi nake, noni potene sani wakwe, ye sani ne minji kenkle one. Whether or not the land, the subject matter of the dispute, is at Sowutuom or at Kwashiman, as the defendants claim. Yes, there be an esani wakwake, and shikon sani na you on and shikon eye Kwashiman me, alo eye Sowutuom me. Whether the land, the subject matter of the dispute, forms part of Kwashiman lands, and if so, whether or not the Sempe stool is the allodial owner of Kwashiman lands, esani wakwake and shikon na you sani ne. And shikpo eya kwashima no mi lo nike eya kwashima no mi and kwashima sempe ma shikpo ni lo. Number 3, whether or not by the judgment in the case of civil appeal number 30/68 entitled Ni Yaudwade Crab versus J.A. Beautiful Kwe. Hey, Beautiful Kwe. Grandpa Beautiful Kwe. Earlier on eba grandpa Beautiful Kwe because ni Kwashiman sane ye yes America grandpa Beautiful Kwe so le America now shanu we Mishi Mamila. Oh my goodness. Yamashia Mamila view. Whether or not by the judgment in the case of civil appeal number 30/68 entitled Ni Yaudwade Crab versus J.A. Beautiful Kwe and others, the Sempe stool, the defendants and co-defendants are stopped per rem judicatum in blamiabo kaga res judicata in blamiabo from claiming title to any land lying to the north or right hand side of the Winneba Road in black BNA miu ehabo. Nkebwa ke neke ya drade case ne inna ko Sempe ma sande ni neke case ne ayo koda mene da ni min nage asma in grandpa in grandpa Beautiful Kwe. Anyways, whether or not the confirmatory purchase by indenture dated 13th June 2002 executed between the Sempe stool and the defendants during the pendency of this action is void ab initio. Jajeke agbenu we masumoni makwake sanene ajensheke 1992 me wa keji Sempe se efe wolo amoko 2002 aneneke wolo ne esane wa kwekla ni wakatuni bona we side esane wa alo for me from the very get go, from the very beginning ab initio waka like waka chonwa yin mepo waka wonkwepo waka bule klapo. Whether or not having regard to the High Court case Peter D. Quarty and 2 others versus Ni Late Kwashi Ahiaku the 5th and another suit number 114/1982, an order that the Kwashima Manche was the de facto Manche and had a prima facie right to make grants of Kwashima lands stops the Abola Piam family from now making claims when they stood by when the litigation over the ownership of Kwashima lands rage. Based on the case and the na year. And Abola Kwashima Manche le peji money yo ebe ni ebanye engo neke Kwashima shipon ko eha because ama no neke Kwashima shipon jinehe ye Peter D Quarte and 2 others versus ni late Kwashima ne ye na me no ene ke shikpon ne ye Abola Piam bi ameba fita na me ba no eko no amenye ni Kwashima bi e no etan ameba ni ameba yuake shikpon ame noni. Whether or not the statutory declaration dated 24th March 1969, registered as number 529/69, was fraudulently obtained. Once again, the registration is on the no near Seneme Kame Sempe, just like you heard. I'm a contact claim. I'm in Chono Wage Jeje, I declare Jeje, Miss Monima Quake, and Ilela Keneke registration. Abola Piami, Fe Yagbenoni Esalo. Whether or not the land, the subject matter of the dispute, is at Sowutuom or at Kwashiman, as the defendants claim. So Jeje Ebaneba Kwe Nibi ni is set forth. Ake Eba Kweno ni eke ye sanene. Kenkle Ebanieba Kwake and any shikon sane, any shikon yo ni ayuo and no eye Sowutuom mi. Alo eye Kwashiman mi. Nya waboti ami. Jeje Ebaneba Kweno first. Now, in paragraph 6 of his original, as well as the amended statement of claim filed on the 20th day of June 1990 and repeated on the 11th day of October 2007, respectively, the first plaintiff averred as follows. The land, the subject matter of this suit is at Sowutuom, Accra. In his evidence to the court, the first plaintiff again emphasized thus. Question. So, ababi lesson. Ene be eta semi. Eta deka me ababi lesson. This parcel of land, where is it located? Abi Mr. Ankrasani. This parcel of land is located in the heart of Sowutuom. Shikpone na you osani, Mr. Ankra. Neke shikpone ingme poten shikpone yo. Mr. Ankra jena ne kake shikpone ni wa you osani. Shikpone eye Sowutuom eting. Sowutuom tende dienche. Abi Mr. Ankra, Mr. Ankra, where is Sowutuom? Nobody Sowutuom. Mr. Ankra, Sowutuom is part of Accra. Mr. Ankra, Sowutuom e Accra. So the land is in Sowutuom in Accra, not so. So shipon wa you are Sowutuom shipon ne Accra mi Jena kan lo. Mr. Ankra Jena again yes. The first plaintiff was emphatic that the land in dispute is located at Sowutuom, and at a cross-examination, he maintained that position. Mr. Ankra, nakele wade kami, ni lelenche lawyer bile sani, ni defendant se un lawyer babile sani, ene domo, ake shikpon na yo sanene Sowutuom miye, jame no jene domo. Ke lawyer ni bile sani ake lelen shikpon ne Sowutuom. Ni defendant say lawyer umba edumojame no echake nani eke shikpon na you osani shikpon ye Sowutuom. Its evidence as to the location of the land was corroborated by the evidence of the second plaintiff, his grantor. Neke no kone ne yue ake shikpon ni ayo ye Sowutuom mi Monique shikpon hale niji second plaintiff ni biamini ayeneke sanene wachayayadi ji second plaintiff at the time like shikpon ha eba yoda si agelele shikpon ni le ehon ke ha Mr. Ankra na kan shikpon Sowutuom mi. On the other hand, in his statement of defense and counterclaim filed on the 18th day of July 1990, the first defendant averred per paragraph 13 thereof that the land is situate at Kwashiman. So again chowake yes, no ni Mr. Ankra yuene Shimon keji okwe na jiemo ni defendant first defendant in this case Mr. Jaben Keba ni no de file 18th day of July 1990 le eke shikpon na you osanene Kwashiman shikpon ni J Sowutuom. Now in the first defendant document of title tendered by the plaintiff as exhibit H, the land is again described as situate, lying and being at Kwashiman. However, the site plan attached to exhibit H described the land as being at North Kwashiman. So on a discrepancy ni your be achono gwage ke okwe wolo kenkle ni echo eni shikon yo ni le defendant ekeha ni this time plaintiff uswe wolo kenkle ni ekeha wolo echo no kwa ke shikon sandi ni ayo shikon ye kwashiman akra Shimon ke okwe site plan ni defendant keba ni ekempia le original title so called ne keba I describe your site plan no wake shikpo ye north kwashiman so original document le defendant keba kenkle eke shikpo document eke shikpo ye kwashiman shike okwe site plan no ne keba site plan eke shikpo ye north kwashiman and of course these are the minute ni bi komeni legally lawyers ba use ni amekba chebosulia not kwashiman and kwashiman is not the same thing but aboni here yo not kwashiman and kwashiman is not the same thing so these are some of the things the boli lawyer for ameinbe ye no papa now the second defendant's initial defense filed on the 18th day of July 1991 was rather terse. It was a 2-paragraph defense. In it, he averred that he acquired one plot of land from the first defendant who had acquired same from the Kwashima Manche. He therefore stated that he stood by the first defendant and adopted the first defendant's defense. He adopted all the averments contained in the first defendant's statement of defense. This therefore included paragraph 13 of the first defendant's defense. By inference, therefore, it was the claim of the second defendant that the land he acquired from the first defendant was located at Kwashiman. So, unfortunately for Mr. Adewale Fioe, a defendant, a claim, a defense, they file a 2-paragraph copy. Me, you know, you hear me 2 paragraphs. Again, no fair, no the first defendant tell you, Leono no you, and I can understand why. Because first defendant tell Jimoni Hoshipon ihale. But I think that is a bad lawyerly work. You understand what I'm saying? That is a bad lawyerly work. You should be able to look at the case of the first defendant, even though ni Leon Shipon habwe. Nyo kwake. What can you do to help your own client? At this point, as a lawyer, you are representing not the first defendant. You are representing the second defendant. I think it is bad lawyerly work for them to just go wholesale with what the first defendant. And look, this happens all the time in the courtroom. This happens all the time. It happens all the time. So, but I think again, this particular case, it was wrong legally work. Ona me be bad defenders pini and ba mo mokome na ba amefa mba kake no ni more you wofen wo here wo me wofen wo keno ya so but I'm saying that I think it's not right. Clearly it didn't go in their favor. So because second defendant tell you na kan iwo belewu mabulake belewu shipon ni le peli oye lewe shipon e kwashima. Now in his evidence, however, he stated that the land in dispute is located in North Kwashiman, sometimes called Sowutuom. So lewe ba yuake ewe no go get chano ake. Yes. Neke shipon ne ene ya achoje me North Kwashiman. Shibe kome achoje me Sowutuom. Now, the third defendant filed a statement of defense and counterclaim on the 20th day of August 1991. A counterclaim for declaration of title to the land in dispute, the Northeast Kwashiman, at Northeast Kwashiman, described in the plaintiff's statement of claim. So, third defendant in this case, mind you, legit Kwashiman manche at the time, ni late Kwashi ahia niji enumu at the time. Achono kwake lewe in 91 a defense ne file le a describe neke shikpo na yo sande ake neke shikpo ne a Northeast Kwashiman. So a movie from Kwashiman to North Kwashiman to Northeast Kwashiman. And once again, kokene adumola yako here if I work say chafon. Kwashiman and North Kwashiman and Northeast Kwashiman, they are not the same thing. God do more call to it, they are not the same thing. Now, me you know ni Sempe me ke yeshikoni ayu osani Sempe me ke the fourth defender, the Sempe stool and the allodial owners of the land stated that the land is situate and lying at Sowutuom in Kwashiman. So once again, Sempe me introduce no conclo to Ameu. Sempe me, yes, the whistle guy, they probably are the same representation as the first defendant. Yeah, probably. Now, Sempe me, I may introduce no conclusion once again. Pay attention. The four defendant, the Sempe stool, and the allodial owners of the land stated that the land is situate and lying at Sowutuom in Kwashiman. So it has moved from Kwashiman to North Kwashiman to Northeast Kwashiman to now Sowutuom in Kwashiman. So defendants for clearly Mokobaka Amelen ni Shikon here. You understand what I'm saying? I may move from Kwashiman to North Kwashiman to Northeast Kwashiman to Sowutuom in Kwashiman. All right, let's move further. So now that's so many that's whilst the plaintiffs asserted that the land in dispute it has Sowutuom and forms part of Sowutuom lands owned by the Abola Piam Tumawi family, the defendants, with the exception of the Sempe stool, on the other hand, initially asserted that the land in dispute is located either in Kwashiman or North Kwashiman or Northeast Kwashiman and forms part of Kwashiman stool lands, with the Sempe stool as the allodial owner. That right there. So Abola Piam in BA, they were consistent. Ake ene Sowutuom shikoni, ni Abola Piam in shikoni. On the other hand, these defendants say Kwashiman, North Kwashiman, Northeast Kwashiman, and Sempe. It appears that the defendants on the 4th day of March 2003 filed a joint amendment statement of defense. Per paragraph 4 thereof, the defendants stated most emphatically that the land in dispute is at Kwashiman. On her lips, he said, Sowutuom. There is a clear erasure or deletion of some words between Kwashiman and Sowutuom in paragraph 4 of the state statement of defense. They try to play a smart one here. Uncle Johnny, not only that, but clearly they tried to play a smart one in the amendment, in the amended statement of claim and amekeba. There is a clear erasure or deletion of some words between Kwashiman and Sowutuom in paragraph 4 of the state statement of defense. That erasure or deletion was done with typex. No wonder counsel for the oh my goodness. No wonder counsel for the plaintiffs in his address reproduced paragraphs 3 and 5 of the said amended statement of defense verbatim. Paragraph 4 states as follows: the land in dispute is at Kwashiman and not Sowutuom. Emphasis my The said erasure or deletion was not initialed. In fact, in the course of proceedings, during evidence in chief of the first defendant's representative, this erasure or deletion prompted the court to intervene. Counsel for the defendants explained that. So I don't know if Aboli, I'm a counselor, I'm a counselor. What I am saying is this: we need to establish specifically where this land is in relation to Kwashiman town and Sowutuom town. Sowutuom is distinct and well-established settlement by itself, and Kwashiman is also the same. We want to find out whether this land in dispute is either in Kwashiman or in Sowutuom. There is a cloud of uncertainty hovering over this explanation. Even in counsel's mind, the land is either in Kwashiman or Sowutuom. So since, to borrow his own words, Sowutuom is distinct and well-established settlement by itself, and Kwashiman is also the same. Counsel was afforded opportunity to initial or make the necessary correction, but he declined. So Ona, you see, look, when you don't have a case, you don't have a case. I try now about Abola Piam. The court then observed thus, and this is captured in the proceedings by court. I'm not writing on the statement of defense. I did it in the record book, and the machine too has captured it. If you will not do the right thing and initial, fine. The records will show that on this day, I asked him to, and he refused. I cannot force you. To which counsel for the defendants retorted, nobody can force anybody. I cannot force the court, and the court cannot force me. We are all seeking justice. Lawyer boom. Lawyer ke jeje en yu agbagbe jeje le mo ni jeje en town e wale ni e initial eni enwe e ke jeje jeje lawyer boom lawyer ke jeje en yu agbagbe defendant sa lawyer e ke jeje en yu agbagbe court ni lawyer jibo no ke jeje en yu agbagbe ni ke So now the first defendant's representative, the first defendant, a representative, leji nga ni akale wadeka mi the whistle get the Sempe pay the lawyer too much or not enough. So Mrs. Ajabe ni akale wadeka mi sande na bile ye neke shikon ne no ne. Let's go on. Again, please tell us the land in dispute. Any other thing to lawyer wabu lawyer ye sande abo ne te de ge court ba ni iliaga ukwo ote lawyer te court de ye sande abo de ge je te funkada Oh my goodness. So, Abilage, please tell us the land in dispute. Where is it? Is it in Kwashiman town or Sowutuom town? Mrs. Ajabeng, in Ajemo na Abilage, and Shikpon Kwashima. Shikpon Sanana, you are Kwashima. Alo Sowutuom. Noni Ekene. Again, the land is in dispute, is lying between Kwashiman and Sowutuom. So na lewo na no na ewie lewo ke shikpon eye Kwashiman ke Sowutuom thing abila ka ni shikpon no wu here no ko wunye here and shikpon eye Kwashiman alo eye Sowutuom e ke shikpon ye between Kwashiman ke Sowutuom thing. Suffice it to say that the defendant's initial defense was that the land is located at Kwashiman. Actually, when shikon kwe ame wolona me ka shikpon kwashima shiagbene ame ka shikpon ye kwashima nke Sowutuom ten na ke Mrs. Ajabe mbata de ka mi. Oh man, let's go on. No wonder, in line with this assertion and belief, the first defendant acquired their land from the Kwashima Manche. The second defendant was also led by the first defendant to initially acquire his land from the Kwashima Manche. The initial stance taken by the defendants was to change dramatically per paragraph 15 of the said amended statement of defense and counterclaim. The defendants counterclaimed against the plaintiff and one Amate killer jointly and severally as follows. The defendants claim against the plaintiff and Amate killer jointly and severally. A declaration of title to all that piece or parcel of land situate and lying at Kwashima / Sowutuom, Accra, ellipsis, emphasis mine. This confusion, I love reading these judgments. I seriously love them. You know, a lot of these, you can actually create movie cry the way any so far judges say ni ameta neke shikon jia no ame opinion say the way na my opinion say trust me, every good writer can lift it up and it will just easily get an documentary alone. It will be so easy. Ghanaian judges are really good at writing opinions. Trust me. Look, I've read quite a few opinions from America. I'm not saying you understand what I'm saying, but the way any Ghanaian judges, I'm a writer, I'm an opinion say kening malojibo ona ni o town yo wo ni o cafe no go etobo. Trust me, etobo kula etobo. You can actually see yourself in the courtroom. Ofane ke o anko wagonti no ni yo nwe ekwe bomode ni o hawe eko onu jani fe mo kiamoko ni lewu eke hamoko kejig bi kenkle nani oba fata boy here ye shiba mi bomode nko ni o subscribe hami min kpabo fai yami wa ade nche bi ene anokwale hia anokwale pe wo yu ye bi ni wo na de kan wo kan yo ne gani bi na efe Sempe njojibu no ka no no mogoneza le abawobo more follow. This confusion in the minds of the defendants raged on. The second defendant, Michael Agbewalefio, filed an amended statement of defense and counterclaim, in which he departed from his earlier statement of defense. Michael Agbewalefio died and was substituted by his son, who caused the amended statement of defense and counterclaim to be filed. As stated, his pleading marked a shift from that of his father, who acquired the land. He counterclaimed against the plaintiff as follows. So I don't know like Michael Agbewalefio ebo na egbo ebile tomoboni onani wakane elia. Ebinu badume na jan. Na ebinu badume na jan echake noni eche defense ni eche ma ke counterclaim echake amendile. Now, many you know a declaration of title to all that piece of land described as Sowutuom, sometimes described as Kwashiman. On a ellipse say, so once again, Leone ba ever introduce Michael Agbewalefio Lewe Binwe ever introduce a different description to the land altogether. Le ekeshipon Sowutuom shibe kome achojeme ake Kwashiman. So we've moved from Kwashiman to North Kwashiman to Northeast Kwashiman to Sowutuom in Kwashiman to Sowutuom, sometimes described as Kwashiman. I agree with counsel for the plaintiffs when they describe the position of the defendants on the location of the disputed land as baffling. They commenced this action describing the land as being at Kwashiman without any credible explanation. They changed the location to Sowutuom and sometimes Kwashiman Sowutuom. Indeed, the first defendant's representative and wife described his place of abode as North Kwashiman, also known as Sowutuom. This same representative described the land as being between Kwashiman and Sowutuom. What is more intriguing is the fact that we are made to believe that in 2002, whilst this case was raging, the defendants acquired new documents in respect of the same parcel of land from the Sempe too. In 2002, namoji Sempe manche nyekami. 2002 ni alotobo, right? Ni alotobo di Sempe manche in 2002. I was in Ghana then. Niotinto, dabi Niotinto, alotobo. So ke ake femina pe. Yes, alotobo. Ke ake femina pa ke biameni sanene ya no na ye na ye kwatanko e. Webi ne ete ni ameti ama ye no konklo ama ye wojin konklo me from Sempe Maadi. Indeed, the reason preferred by the defendants for the procurement of the documents from the Sempe stool was that they subsequently got to know that the same Sempe stool was the allodial title holder. The documents were tendered in evidence by the first plaintiff as Exhibit 1 series and Exhibit 1 series. So I'm a tenamae because I'm an ameliake Kwashima Shipon Sempe Mano, no Kamukubafe Wuluya, man, but it's an Sempe new one amite. But unfortunately for them, look at what happened. Both documents of title, the land in each case was described as being at Sowutuom. So even in their attempt to change documents, even in their attempt to change documents, it didn't go so well for them because documents are not chaki. It described any shikpo or yo as Sowutuom and not Kwashima. Again, thus the initial contention of the defendants as to the location of the land being at Kwashiman changed to Sowutuom without any explanation. You understand what I'm saying? So it changed. So wolo here na ma Sempe ma de Sempe me chake age shikpone ebe Kwashiman don shikpon sane na me yo shikpon yes Sowutuom. Now mind you, no ni wa you on efe jeje number one, answer. I think JJ lay about 4 things. Ni eba answer. Eba sumoni wakwe. First one, whether shikpon Kwashiman, alo Sowutuom. So no. Well, you all be and we'll move go on to the others. So let's stay right on. Again, that's the initial contention of the defendants as to the location of the land being at Kwashiman changed to Sowutuom without any explanation. The reason for the acquisition of the new document was explained. However, the reason for the change in location was never satisfactorily explained. So, yes, I'm a blami. Ni I'm a chon no ni amae wolo ye Sempe ma de because I'm an ameliake Kwashima shipon Sempe ma no. Shimon no ni ewo Ni any shikpon yo a chake from Kwashima to Sowutuom no ele amenya make bla mi odugba. So once again, mind you, ya me ni bi ami no now I may move away from Kwashima to North Kwashima to Northeast Kwashima to Sowutuom in Kwashima to Kwashima, sometimes called Sowutuom, or Sowutuom sometimes called Sowutuom, to explicitly Sowutuom, based on Wolue ni adoto buake ha me. You understand? So I'm letting Jame answer question mopo. Now let's go on. After all, to borrow the words of counsel for the defendants, Sowutuom is distinct and well-established settlement by itself, and Kwashima is also the same. Therefore, there ought to have been a reason for the change in description or location. The court makes a finding of fact that the land in dispute is situate, lying, and being at Sowutuom. So clearly, based on Kenoni wolu na ma Sempe madi ni Sempe me describe any shikpon yo at Sowutuom me jeje ke e ba du monono ne ba yue ake e find di e ba conclusion ake sani any one tao what yue ake one tao wole ake ani shikpon na you sani ne e ye Sowutuom alo e ye Kwashima jeje ke e find di ake ne ke shikpon sani na yo e ye Sowutuom. The court further finds that Sowutuom is distinct and well-established settlement by itself, and Kwashima is also the same. Lawyer Jibo no oto ke je challenge na je efa na kan we money le lawyer ewe no ne ba wo je me. She court any of one hour le ake Sowutuom ji any shikpon na yo sanene ji any yo je Kwashima. The resolution of this issue does not in any way resolve the issue of ownership or title to the land in dispute, or for that matter, Sowutuom lands in general. So yes, diane 1 hour leake shikpo ye na pelio shikpo ye mana chole Sowutuom memi shimon no echo money poten ni Sowutuom shikpo jin fe le noni no nya ni woboti ami agbene ni wokwa. Na number 2 diane wa fe wa na ake shikpo sane na yo e Sowutuom jeje keshimo no echo kwa ke Sowutuom me Sempe mano alo Abola Piam no nya wa ya no. Number 2 mini jino ni jeje ke agbene e ba tawe 1 hour le ake shikpon achoje me Sowutuom shikpon na apelio e bia ne ye sande ne mi achoje me Sowutuom agbene na wa second one no jeje ke agbene nya wa kwa ake whether or not the confirmatory purchase by indenture dated 13th June 2002 executed between the Sempe stool and the defendants during the pendency of this action is void ab initio. So jeje ke agbene we sande wa kwa ake neke indenture ke wolo ni Sempe me fe neke defendants ne biami na ye sani oloe ani nakano wafo min kla ni waka kwelo tumoboni plaintiff said tawo ni wafe ani wafo min kla ni waka kwelo waka kwele kla from the very get go. We should just completely ignore it ab initio waka kwekla waka recognize the klapo. It is null and void from the very get go. Don't even worry about it. Don't look at it. Pay attention. Let's go. According to the attorney for the first defendant, she and the husband first acquired 2 plots of land from the Kwashima stool. Exhibit H was executed by the parties thereto to evidence that grant. However, on learning of the Kwashima stool is under the Sempe stool, they approached the Sempe stool. After a physical inspection of the land, they were given another document, Exhibit J, covering the land to confirm the earlier grant made by the Kwashima stool. She admitted this under cross-examination on the 7th day of June 2012, when she stated, question, according to you, the document that the Sempe stool gave was to serve as confirmatory grant of the previous one you had from Kwashima. Is that not so? Okay, correct. I be like, so wolo here no ya Sempe ma there. Just otadi no afe no mima. Ken wolo ken clear ni kwashima mbi efe habu eje na kan lo ike. According to the first defendant, therefore, Exhibit 1 was executed by the Sempe stool to confirm the earlier grant made by the Kwashiman stool, Exhibit H. The evidence of the second defendant concerning the alleged confirmatory grant was not different from that of the first defendant. Indeed, the pleading and evidence of the second defendant was that Exhibit Agbewalefio 1 was only prepared and executed later by the Sempe stool to confirm an earlier grant made to his father by the Kwashiman Manche. Exhibit Agbewalefio the first was therefore supposed to be a confirmatory grant. The issue is whether Exhibits J and Agbewalefio 1 actually evidence confirmatory grants made to the first defendant and his wife and the second defendant, respectively. The third recital to Exhibit J indicates that there was a prior or earlier grant of the land in dispute made to the first defendant and his wife in 1988 by Ni Kwashi Ahiaku, the fifth Kwashima Manche. Thus, a fair reading of Exhibit J shows that a confirmatory grant arises on a consideration of the operative part. Consequently, one is tempted to conclude that the conveyance of 30th June 2001 confirms the earlier grant made to the first defendant and his wife allegedly made on 18th May 1989. I have taken a critical look at exhibits H and J. In Exhibit J, whilst the site plan attached to the indenture was allegedly prepared on 29th day of November 2001, the indenture itself was executed on 20th May 2001. In other words, the indenture was prepared and executed before the site plan was prepared. However, it is trite learning that it is after the preparation of the site plans that a parcel of land are described in the indenture. The only conclusion one may arrive at is that the site plan was prepared and attached to the indenture after the land had been described in the indenture. It is an anomaly. You see, respectfully, Keji Omale be Obamale no okay channel, Obamale. So clearly, Amechono say they are doing things on the back end. Yeah, you understand what I'm saying? They are doing things on the back end. They are doing it on the back end because I'm going to send it a court. Attached to the indenture that the land, okay, more importantly, whilst the term of years created under Exhibit H is 99 years, it is 50 years in Exhibit J. Secondly, whilst the date of commencement of the term created in Exhibit H is 18th May 1989, the date of commencement of the term in Exhibit J is 1st January 1988. You get once again, and look, and this is what happens when I'm sorry. Sempe may tried to steal something. They tried to steal from Abola Piam. They tried. This is thievery being exposed in court. This is thievery being exposed in broad day court. Again, night day, broad day. So because clearly they are trying to pull a fast one. They are trying to pull a fast one. The court was able to see through every single thing. The dates changed, the number of years changed. Nibia Venchaki. So once again, it goes to show you like this confirmatory grant need the intent. I mean, if you're trying to issue a confirmatory grant on an earlier one, why should the terms change? The years changed from 99 to 50. date check from 18th May 89 to January 1st 88. You are only issuing a confirmatory grant. The details should not change. It should be the same. Oh, Sempe, Abola Piam, Maga Pele Ashmo, Jenum, Sowutuom, you know, Nega woman, Jendo. That's just a fact. Iliaka Abaya Feno, Numo Folie, she got Numo Folie, Sempe, Nega woman, Sowutuom, don't, Nishi Abola Piam, be an army to a manche, Jemmy. Cabonia Bale, Nagayale, at some point, Numo Folie Bagbo, Kegbo, Nega woman, Sowutuom, don't Sempe me. Nyega to amanche Sowutuom don nyeshi Abola Piam bi na ameto mugwenye ne kwashipon no yame. It is not yours. Court exposing everything that you try to do in the back end. I mean, I expose it so badly, so badly. Yeah. The whistle, absolutely. Now, however, the issue at stake is not about the confirmatory nature of exhibits J and Agbawalefio 1 series. The issue is about the ownership of the land in dispute. And this is a perfect segue to the third thing that the judge wants to find. Whether the land, the subject matter of the dispute, forms part of Kwashima lands. And if so, whether or not Sempe stool are the allodial owners of Kwashiman lands. So agbena akwe ake ani no na you Kwashiman biano e Kwashiman biano ani Kwashima e Sempe shishido Sempe ma ashwon jije melo. Let's go on. Having resolved the issue of location of the land in dispute, the further critical issue which of the two families, i.e. the Abola Piam Tumawe family and the Kwashi Anyako family, owns Sowutuom lands. So biane abanabaye money owner Sowutuom lands. Say abanabaye. So mind you, I move from this piece and parcel of lands ni a year to atana jeje tana ye na kwe Sowutuom shiko GFN na mano. Jame washe. Let's go on. And in another sense, Kwashima unwe na mano. Nika Kwashima keneke shikone Kwashima miani Sempe mano nilu. So let's see what the court says. This ultimately involves the claim of the Sempe stool as the allodial title owner of all Kwashima lands, including Sowutuom lands. Look, you can even tell from here, they will lose the section because JJ already declare Sowutuom is distinct from Kwashima. This were not her words. These were the words of the lawyer for the defendants. Sowutuom is distinct from Kwashiman. So clearly you can tell they've actually lost already based on I can find here earlier. Now, but this ultimately involves the claim of the Sempe stool as the allodial title holder to all Kwashima lands, including Sowutuom lands. So Sowutuom is distinct from Kwashiman. Now let's go on. But I can understand why I need a push again, because I guess Sowutuom, sometimes known as Kwashima or Sowutuom in Kwashima lands. So it is a contention of the plaintiffs that Sowutuom lands are owned by the Abola Piam Tumawe family of Accra. In support of his assertion, the first plaintiff tendered in evidence exhibits K series, LMNPQ series, STUU1 and AA, BB, CC, DD, and DD1. Now, Exhibit K series is a statutory declaration made by one Amponsa Ankra, who described himself as the head of Abola Piam Tumawe family of Accra. It is dated the 24th day of March 1969. It is registered with Land Registry number 1529/1969. Exhibit K series declared Abola Piam to be a branch of Tumawe family of Abola. It recounts the origin or the root of the family's title to Sowutuom lands. According to Exhibit K series, the family originally migrated from Ayawaso with the Gans under King Ni Ayi around the year 1680 to 1700. Exhibit K series further recites that on arrival at the coast, the said family settled on the lands known as Sowutuom lands when they founded villages known as Sowutuom, Ologobi, Ologobi, and Chantan. Did I hear Neke Ologo? Oh, okay. So Ologobu. Remember, if you guys remember, as of Kotega, che Neke Ologobune. You guys remember, right? Those of you who were with us yesterday, I can Neke area name in there. I charge them Ologobu or something like that. So no, I mentioned here Neke no name. They founded villages known as Sowutuom. I think it's Ologobu, ni ame type Ologobi and Chantan. In sum, the evidence as captured in Exhibit K series was that the Abola Piam family of Accra obtained their land by original settlement. The second plaintiff's attorney, Tetechulu Ade, confirmed the grant made to the first plaintiff by Charles Okain Boche and Matthew Adote Alote, the then joint heads of the Abola Piam Tumawe family. At the time of taking evidence, the head of family was Joseph Yaya Ade. His attorney also corroborated the evidence of the first plaintiff as to the ownership of the family of Sowutuom lands. A normal incident of ownership is the right to make grants of the property. If indeed the allodial title to the land in dispute is truly vested in the Abola Piam Tumawe family, it would seem natural to expect that family to make alienations of this property or authorize such alienation. There is the unchallenged evidence of the second plaintiff on record that grants portions of Sowutuom lands were made by the Abola Piam Tumawe family. Such grants include a grant made by the family to the Catholic Church for a seminary as per Exhibit A, and another grant made to the Volta River Authority, VRA, as per Exhibit BB. The defendants made an attempt to discredit these grants. They alleged they challenged any grant made by the Abola Piam family. Exhibits AA and BB are registered documents. The grants were all made in 1979. Since 1979, no action has been taken by either the Sempe stool or the Kwashimon stool to have these grants set aside. Mere allegation that they challenged these grants will not be enough. Evidence of those challenges was not given. These alleged grants were meant to be evidence of ownership of Sowutuom lands. So, neke registration ne can be na me challenge on fe Abola Piam bi e ame bagbasane ake ame jetuma we ayi kushi ji ame che le na jaya waso na aba ni ame batoji jeme ni ame tuma ame Abola Piam bi ni jetuma we mi ame shikon ji jeme ologobu Sowutuom Chantan kana ganjeme fe ama me to jeme ame register shikon sempe meke dabi je ama me noni je ke ameka wojie badi twage ameka shikon eko ya Catholic Church ameka shikon eko ya Volta River Authority ni sempe mele ameka me na buka ke ba yue ameka woloko ba ni ba twage ame challenge ne gani bi na fe. The second plaintiff further informed the court that his family shares a common boundary with the Awule Mona family of Ufanko, among others, and tendered in evidence Exhibit CC series in support of this contention. Again, he stated that in 1953, the then Gold Coast government mined gravels and sand on the land, and the family put it in a claim. After some discussions in 1956, the government conceded that they were the owners of the land and paid the sum of £80 to the family. It tendered in evidence Exhibits DD and DD1 in support. Exhibit L is an advertiser's announcement which appeared at page 12 of the January 24, 1967 edition of the Daily Graphic. It reads, neke daily graphic no ne eyolo nkechonye. If you guys remember, nkechonye several times. Public notice. Abola Piam family lands, Sowutuom lands. Nkechonye. Biamini wonfe neke nukonin. It is hereby notified for the information of the general public that all that piece or parcel of land situated, lying and being at Accra, in the greater Accra region of Ghana, known as Sowutuom lands, and bounded on the north by River Isaki and Ofankor village, on the south by Kwashiman village, and Assurance 2 lands on the east by Onomraka Odai and Awulemona family lands, and on the west by Ablekuma and Oraman villages are the ancestral property of the Abola Piam family in the Abola division of Accra. It was signed by Ni Amponsa Ankra and William Ni Kwamina Owu Ade, the joint heads and lawful representatives of the Abola Piam family. This publication sought to create the impression that the Abola Piam family owned Sowutuom lands. It concerned Sowutuom lands. It gave a description of Sowutuom lands and warned the general public against dealing with persons other than the accredited joint heads of the family. The description given in that publication conforms to descriptions given by the parties to the suit, i.e., that Sowutuom is to the north of Kwashiman. Exhibit M is also a publication in one of the dailies. It concerned a dispute between the Mamon family and the Kwashiman Manche involving Kwashiman lands. He never made reference to Sowutuom or the Abola Piam family. I wonder why it was tendered. The impression was created that by virtue of a public notice in the Saturday edition of 8th July 1995 at page 13 of the Daily Graphic, the Manche Ankra family refuted the claims of Ni Amponsa Ankra, the author of the Abola Piam to Mawe family declaration, to Sowutuom, into parentheses, Kwashima lands. This was clearly stated in paragraph 3 of the 4th defendant's amendment statement of defense and counterclaim. To counter this assertion, the plaintiffs tendered Exhibit S. Exhibit S is a public notice on Manche Ankra family lands. So, Manche Ankra be nyonye beno go Sowutuom. Nye claim o Manche Ankra be go me claim age amishpo Sowutuom. Amakandi egole jenaka amakandi. This was clearly stated in paragraph 3 of the 4th defendant's amended statement of defense and counterclaim. To counter this assertion, the plaintiffs tendered Exhibit S, which Exhibit S is a public notice on Manche Ankra family lands. The said public notice was caused to be published by one Ni Kweku Ankra II. He described himself as the head of the Manche Ankra family of Dadebana, Otublohum, Accra. The subject matter of that publication was Manche Ankra family lands. I do not think we are being made to believe that Manche Ankra family of Dadebana, Otublohum, Accra is the same as Abola Piam to Mawe family of Accra. So Sempe may tender in saying, okay, but why would you even tender that in? It still does not further your argument. Okay, the Sowutuom lands belong to you. Keji Manche Ankra weku ni ameka Abola Piam be at some point I may have issue. Yes, Sowutuom lands that in itself so I don't even understand why this will be tendered. But anyway, let's go on. Oh, this was actually tendered by the plaintiffs. Okay. So yes, all right, let's go. And in Exhibit S, the family is described as Manche Ankra family of Dadebana. I jumped ahead of myself. I thought this was tendered by the defendants, but it was actually the plaintiffs that did this. In this case, the family under reference is the Abola Tumawe family of Abola. Nowhere in that publication was the name Abola Tumawe family of Abola mentioned. For the mere fact that Sowutuom was mentioned in that publication cannot mean the two families. Abola Piam Tumawe family of Abola and Manche Ankra family of Dadebana, Otublohum, Accra are the same. They are the same family. Yeah, okay. Okay, let's go on. Maybe a story will be told. Now, it could be, so I don't know. I'm just going ahead of myself. Enough of the conjecture from me. Let's go on. In that publication, one Ni Ayi Ankra the First was portrayed as an usurper to the headship of the Manche Ankra family and warned the general public to desist from dealing with the said Ni Ayi Ankra with respect to Manche Ankra family lands. It further refuted the claims of the said Ni Ayi Ankra the First that the Manche Ankra family owned certain lands described in the publication, including Sowutuom lands. Okay. So okay, I understand why the plaintiffs submitted this. So that the ban be I've heard quite a few of them claim okay, Sowutuom. No. So this was submitted by Ni Ayi Ankra ni kakelejo nupa kan manche wekue ni eba yue ni Ayi Ankra ne no me manche Ankra weku nupa eba describe shikonji ni eye manche Ankra shishi manche Ankra weku shishi ni Sowutuom fitai shi wache Ni Ayi Ankra ne eba counter noni neke manche ayi neke manche Ankra weku nupa ne jebda de bana yue ake dabi ame manche Ankra weku ame be shipongo Sowutuom. Unless we are being made to believe that the Manche Ankra family is the same as Abola Piam Tumawe family, and that Ni Ayi Ankra the First is the same as Ni Amponsa Ankra, I do not see the link between the said publication and the subject matter of this suit. The pleadings and evidence do not disclose that the Manche Ankra family is the same as the Abola Piam Tumawe, or that Ni Ayi Ankra is the same as Ni Amponsa Ankra. Okay, so anyways, be a Mr. Ankra, but no man no one is it to once again push off that the banner because in like Mr. Ankra, I'm a to blow BG. Bona. So Niliake, I say Abola Piami. No one your Wokunu Abola Piami. So what was this publication really? What was he trying to prove with this publication? And what meaning of your case? Clearly you can tell the judge was confused as to why Mr. Ankra produced this particular piece of evidence. So ena no. Exhibits T and U are the results of searches conducted at the Lands Commission on 27 July 1990 and 4 February 2011, respectively. They disclosed that the declaration made by Ni Amponsa Ankra has been registered. Exhibits V and W are composite plans produced to the court showing the respective locations of the parties' plots of land. Exhibits AA and BB are grants made by the Abola Piam Tumawe family in favor of the Archdiocese of Cape Coast, acting for and on behalf of the Ecclesiastia province of Cape Coast in trust of St. Peter's Seminary, Pedu, Cape Coast, and the Volta River Authority, respectively. As stated supra, although the defendant disputed these grants and alleged that they challenged him, no credible evidence was provided to establish that these grants have been set aside or that an action has been taken against those grants in respect of those grants. Exhibit CC is also a statutory declaration made by Awule Mona family of Ofanko. To Exhibit CC is attached a site plan in which the Awule Mona family describes its lands. To the southwest of the Awule Mona lands are the lands of the Abola Piam family. Exhibit DD1 is a letter from the chief of Ofanko to the commissioner of lands department. The subject was the Insemwan Road, mile 9, query site. It sought to refute the claim of the Sempe to Sowutuom. So once again, Mr. Ankra a produced nekeno kone ni once again. Biami ni government acquire neke query ne Kenya bakaye. This was also tendered in the case against Aseneme by the Abola Piami family. Ni chono kwa Sempe me abemeno ko klomo ye Sowutuom. In contrast, the first defendant derives his title immediately from the Kwashi and Yaku family of Kwashiman, and derivatively, from the Sempe stool. Exhibit N series tendered by the first plaintiff is also a statutory declaration made by one Ni Late Kwashi Anyaku of Accra on the 16th of October 1972. He also described himself as the head and lawful representative of the family of Kwashi Anyaku and a grandchild of the late Kwashi Anyaku, who died intestate in or about 1896. It is registered with the land registry number 1735/1972 according to Exhibit N series. All that piece or parcel of land described therein from time immemorial belonged to the people of Sempe. However, in 1978, Kwashi Anyaku approached Ni Sakachulu I, the then Sempe Manche, for a piece of land for farming and residential purposes. The Sempe Manche made a grant of the land described therein to him for the good services rendered to the Sempe stool. Unlike Exhibit K series, this piece of evidence on the land claims that the Kwashi Anyaku family acquired the Kwashiman lands from the Sempe stool. It is not clear whether the alleged grant was by way of gift. It only talks of that fact. So yes, Kwashi Anyaku wekue ameyeshipon yesempe maadi as far back as 1798. Kwashi Anyaku approached Ni Sakachulu I, then Sempe Manche, for a piece of land for farming and residential purposes, and the said land and the heritage were customary granted to him for the good services rendered to the said stool, and money's worth absolutely and free from all encumbrances forever. The declaration was made on 16th October 1972. What beats my imagination is why the declarant therein did not consider it prudent and expedient to procure a formal document covering the land from the Sempe stool. The stool, as a perpetual existence, it was the Sempe stool and not Ni Sakachuru I, which allegedly made the grant to Kwashi Anyaku. In 1972, Ni Sakachuru might not have been alive, but the stool was in existence. The declarant could therefore have approached this grantor, the stool, for a document on the alleged grant made by the Sempe stool to Kwashi Anyaku in 1798. Eto Julagbene, we are getting there. It must be noted that both Exhibits K and N are statutory declarations executed by the declarants therein. The courts have had the occasion to comment on the evidential value, legal effect, and or efficacy of statutory declarations in land litigation. In the case of Ayekpa versus Sakimensa, 1984-86, number 1 Ghana Law Review 172 CA, the Court of Appeal stated, the statutory declaration given to the plaintiff was not a conveyance because he did not seek to transfer whatever title the vendor had in the plot to the plaintiff. On its proper legal analysis, it had no more potency than a contract for the sale of land. Similarly, in the case of in R.E. Ashaleboche lands, Ajete Sowa and others versus Kote and others, 2003 to 2004 Supreme Court Ghana Law Review 420, the Supreme Court stated at page 451, the more important question is whether this document, which I ever think is not a registrable document under the Land Registry Act 1962, Act 122, creates any proprietary right in them. I think it does not. True, the declaration is document in writing affecting land situate in Ghana, but it is not a deed or conveyance, nor does it purport to create or convey an interest in land. It's continued at page 452 that generally statutory declarations per se are self-serving documents and so of no probable value where the facts contained in them are challenged or disputed. The two families have seriously challenged and attacked each other's documents, i.e. Exhibits K and N. The sum total is that Exhibits K and N, as far as title to Kwashiman and or Sowutuom lands, are or is concerned carry no potency. Both declarations are self-serving documents with no probative value. The court can refuse to attach the needed weight to them since they have been challenged or controverted. The declarants therein only declare title in the lands described in their respective documents in their respective families. The two documents merely contain declarations on behalf of their respective families in respect of the specified areas of land described in the declarations. I would therefore be cautious in assessing the evidence value of these two documents. Did any of the two families therefore offer any credible corroborative evidence in support of any of the facts recounted in the declarations? I have found as a fact that Sowutuom and Kwashiman are two distinct and well-established settlements, and that the land in dispute is located in Sowutuom. Whilst in Exhibit K, the Abola Piam family described its land as being at Sowutuom. In Exhibit N, the Kwashi and Yaku family describes its land as being at Kwashiman. The Kwashi and Yaku family and the Sempe too, however, explain that Sowutuom forms part of Kwashiman. Hey, Sempe me. Yes, Sempe me fe. Chemeli nyame ye na chune genu chumone. Over the jadi fe mo yami kiamoko dile we kiamoko nu jadi fe mo yami. Girl like you go show yami but when they don't like you show yami she baby over fit our first time there I mean subscribe more be a call town no na anukwale so what can your wolu efe abo waka wana abu eke ebo no koi can what be evidence what ke ebo oba ke ebo ke evidence was mo no ba no mo go ne sa so oh, yeah, me say, baby. Yeah, what day? Where? Anyways, let's go on. Indeed, they sometimes describe the location of the land in dispute as being at North Kwashiman or Northeast Kwashiman. The other explanation is that Kwashiman and Sowutuom are all villages of the Sempe too. I'm unable to agree with this explanation. Although no attempt was made to substitute him, Kwesi Ahiaku joined the suit as the Manche of Kwashiman. If truly Sowutuom forms part of Kwashiman, and its traditional jurisdiction extends to Sowutuom, as we are being made to believe, it should have been projected also as the chief of Sowutuom. However, one ni Ado Ayi Kwe the first, the fourth defendant witness, introduced himself as the chief of Sowutuom. Hey, Sempe me. Shikoni jenye nyenoni. Nyen tomanche jeme. Oh. Actually, yeah, Dadebana be Dr. Jesse Ankra. Ni nyeleje Dr. Jesse Ankra. If audio ege manchankra we be a nyebeno go kla klom we Sowutuom naga audio ake ami be ko shimi naga asa ake ami ko I believe aga naga audio ami ko so that e ba na be mi gba ifai nyede nche no Dr. Jesse Ankra ege nyebeno go klom we Sowutuom Abola Abola Piam biado so over ko e dade ba na nyeji anyedwomo yes Sowutuom shikonji yana le nyedi enche no if Mr. Ankra nyeno nie Mr. Ankra no ba yu ehye Dr. Jesse Ankra ba yu ehye so ko je dade ba na over nyebe no go klom Sowutuom nyepa so like I said ni akwe ofoli be an Judgement Sowutuom ni a representative Sempe. Like I said, look, Sempe me ke choice I don't know clearly as it stands now. Look, Abola Piam be a banya take a banya me taking your own ni ofoli a manchene you Sowutuom about declare null and void. because Jason Sempe mashiponi about declare null and void. Shike amefe na kan ni tomobeni abale na kan yale ne choice nyega wa manche Sowutuom don Sowutuom Sempe me jenye nyeshiponi nyega wa manche gendon Abola Piam bi ba nye to manche jeme ni le kwe ne ke shiko ji na fe ni yo jeme ne ke o manjo ke ni bi na fe amamba to manche Sowutuom ne kwa jeme fe ha me o na boni ni yo. So like I said, I don't know if Abola, it is in their right bi aneno na me ba pursue ake nye manche ni yo jeme esa na yo manche jeme ni ameba win easily Sempe back case kokla no ne wona isa na to manche Sowutuom a back case court declare akeshipon J Sempe mano shipon ni jo no ne onyo to what is the Latin term ni lawyer for use so you cannot give what you don't have Uncle Johnny me Latin term ni kefi lawyer for use so lawyer for ka nyen kwami iye pa no eya inchomi iye pa no lawyer for Latin, there is a Latin ni legalese now use so you cannot give what you don't own. So nyenye to manche shikoni je nyenye no ni you cannot iye pa Latin term no shikwa machemanye. Let's go on. No. Oh, Minister Dede. I hope you guys can still see it. Okay, let's go on the BNA. So let's go. Okay, here we go. However, one ni Ado Ayi Akwe the first, the fourth defendant's witness, introduced himself as the chief of Sowutuom. Exhibit EE, tendered by the plaintiff through the fourth defendant, is the Thursday, July 1st, 2004 edition of the Daily Graphic. It showed a picture of Ni Ado Ayi Akwe the first, swearing an oath of allegiance. Imba Neboji Ado Ayi no Oto Yeme. Odabi Jebu, I got to tobu. Okay, imba kanelo ban lagabu. He showed a picture of Ni Ado Ayi Akwe the first, swearing the oath of allegiance to Ni Adote Obuo the Sempe Manche, and acting president of the Traditional Council. In the news item accompanying the picture, it was stated inter alia, thus, Sempe Sowutuom was created inter alia, among other things, was created more than 20 years ago by three clans. They are Sempe, which has 90% stake in the town, Aswe 5%, and Abola Piam 5%. Oh, Sempe me. Oh, Sempe me. When you got 90%, TJ. Sempe me. Sempe me. Shikoni jenye no nyanye 90%. Nya asene me 90%. Nya Abola Piam mbi na ma me shikoni nya me 5%. Hey, aguje. Aguje gangsters ya me kanya che. Aguje. Oh, I have a mafia one time. Go je one day. She go ni je no. Ni je 90% ni Sempe me just. Sempe me have 90%. I have 90%. Now me I send me 5%. Now me Abola Piam mbi na me shponi ani Sempe. Sempe me ame. Well, I watch you. I don't think I watch you. I go for young man. Hold on, I watch you. I we go take on by force. Kwe Sempe aba kwe anye no Sempe sko me anye no Sempe sko me anye no Sempe sko me oh my goodness. To my mind, the importance of this publication as far as ownership of Sowutuom lands is concerned is the fact that it acknowledged the right ownership, however partial or marginal, of the Abola Piam family in Sowutuom lands. Lesson 1. Exhibit E itself may be considered as a declaration against interest. It is a declaration made by the Sempe stool against its own alleged proprietary interest in Sowutuom lands. In the case of Harold Kwame Tamaklo and another versus Faustina Wood, substituted by Nana Kweku Quarantine, Part 5, 2006, 5 MLRG 132, holding 1, per Esiama Justice. As he then was, it was held that a declaration against the proprietary interest of a person holding himself up as the possessor of a named property has always been held to be the truth in the matter, and that he or she is not the true beneficial owner of the named property. In stating the legal basis in accepting the declaration against interest as truth of the matter stated in the declaration, Fetches Morton LG in Tucker versus Oldbury Urban Council 1912 12 KB 312 321 said, such declarations are admitted on the ground that declarations made by persons against their own interest are extremely unlikely to be false. Such declarations are admitted on the ground that declarations made by persons against their own interest are extremely unlikely to be false. Literally, the probability I can only more you share here, it's BBO, because Sempe in that news publication there, I may admit Abola be a owner a percentage of the Sowutuom lands, albeit a small portion. Even though I may marginal, like albeit a small portion, that is their acceptance. Abola Piam they own something. Yeah, Sowutuom. Even though now they are claiming Sowutuom land say belongs to Sempe. Like publication ni outdoor ni ado ayikwe ni jikenkle Sowutuom manche Sempe me agree yes Abola Piam bi ame no go club we Sowutuom no ni echo to no go look echo to this Sunday go na ye 1912 to la na ka mo go yue no go ni mo yue no go ehie here onyo ka no ni mo yue je na kan so le no ni Sempe make ba fe Sempe they actually shot themselves in the foot, and look, it clearly shows look she kon je amame no ni Sempe me clearly nibi ni nyeke ba fe e chon ake she kon je nyenye no ni. And I'm saying it again, ke Abola Piam bi ameke nye ya court ni manche ni nye wo eje me aba afo mi ke ni akwe osabugbo nyega wa manche Sowutuom don je nyenye she kon ni. You cannot give what you don't have. Now, the publication and its contents have not been denied by the Sempe stool. In any case, Niadoayi Akwe the First was a witness for the first defendant in this suit, and he made effort to discredit the said publication. The only conclusion one may arrive at is that it was the Sempe stool which invited the newsman and caused the publication of that news item. Ona no nkane elia kamo go yue no go elelenche here onyo ka ka ebemi amena amento amemanche ni amena ameani abakova if you ten ameko age no na agma emi je na gaini. Be I mean na amena noni a publication and maybe a rejoinder. Amena. This publication for the first time creates the impression that there is another Sowutuom called Sempe Sowutuom, created by these three entities more than 20 years ago. Sempe Sowutuom. That stakes in Sowutuom have been divided by these three alleged clans. Yep. That's creating the impression that the three clans, namely Sempe, Asore, and Abola Piam, jointly own Sowutuom. It further creates the impression that there was or is another Sowutuom in existence before the creation of Sempe Sowutuom more than 20 years ago. Again, it could be inferred from the publication that Sempe Sowutuom is of a recent creation as compared to the traditional evidence of the Abola Piam family that Sowutuom was founded between 1680 and let me see something. Why am I? Yep. That Sowutuom was founded between 1680 and 1700. Refer Exhibit K series. If truly Sowutuom forms part of Kwashiman, then the contents of the publication, as far as the year of the acquisition of Kwashiman or Sowutuom is concerned, further conflicts the contents of Exhibit N series, which is the statutory declaration of Ni Late Kwashi Anyaku. Look, Sempe me ame try akabeba mafia ni aname. Look, kotu e jame duna ko baba o nye benoko noko. Sempe me nge nye benoko noko club. Evidence ni nyeke ba fe go against nye. Every so far ni wakan yo kemi mali nye kami. Every single thing in kanye ni Sempe me ke ba go against me. Every single thing I may produce go against me. Every single thing. No, that then had a lawful representative of Kwashi Anyaku family that in 1798 the Sempe granted Kwashiman lands to his family. It further contradicts the evidence of the fourth defendant's representative that it is a Sempe that elects elders, they install chiefs, and also they are in charge of the villages. Since in this case it would then be the prerogative of all the three clans to elect elders and stool chiefs and also be in charge of Sowutuom. According to him, these three villages include Sowutuom. It must be remembered that it is the evidence of the defendants that Sowutuom falls part and parcel of Kwashiman. The circumstances leading to the formation of the so-called Sempe Sowutuom were never explained, and neither was the issue of how the alleged stakes were apportioned explained. As stated supra, the Sempe has not made any effort to refute the allegations contained in Exhibit EE series, and neither has it published any disclaimer. We are not told when this triumvirate was formed. I don't know this word. First time seeing it. We are not told when this triumvirate was formed, considering the extent and depth of differences between the Sempe and the Asore as far as the ownership of Kwashiman is concerned, as evidence in Exhibit Sempe 6, and also between the Sempe and the Abola Piam family as far as ownership of Sowutuom is concerned. I'm unable to believe the contents in Exhibit E. It is a self-serving document meant to serve the interest of the Sempe. No ni Sempe make ba ni chwanke Abola Piam Sowutuom mama no je kwe ene no go na make ba ni. It is a self-serving no go me. Exhibit Sempe 6 is supposed to be an award of an arbitration panel between the chiefs of Asore and Sempe concerning the installation of chief of Kwashiman. The panel of arbitrators was headed by the Gamanche, the late Niamugi II. The main dispute, however, concerned ownership of Kwashiman. Sempe me eno nyekaba Kwashiman Sunday, je Sowutuom Sunday. The arbitration was held on the 21st day of September 1966, according to the defendants, by Exhibit Sempe 6. an award was made in favor of the Sempe stool. By inference, the Sempe stool was declared owner of Kwashiman. Sowutuom is supposed to be part of Kwashiman. And surprisingly, manya min kaneni olo
Sorry.
Manya pa do enye show no bagbena. Manya pa enye show no bagbena. Let's see how many pages we got left. Exit. What? Yeah, 1 second. The panel of arbitrators was in Kanejamo. Okay, so Sowutuom is supposed to be part of the Kwashiman, and surprisingly, we are being told that in 2004, the two stools, together with the Abola Piam family, formed a triumvirate, to jointly own Sowutuom, which is supposed to form part of Kwashima. However, as noted in this suit, there exist differences between these two so-called clans. Indeed, Exhibit Sempe Stool 6 is only a report on an arbitration held under the auspices of the late Gamanche, Niamugi II. It concerned the installation of a chief at Kwashiman. Essentially, it concerned the ownership of Kwashiman lands. It recounts the respective versions of the Asore and Sempe Stool on how Kwashiman was founded. I have perused Exhibit Sempe Stool 6 and have come to the conclusion that the panel did not make any award in favor of any particular party. In fact, from the exhibit, one can safely conclude that the panel did not conclude its work. The panel did not declare Kwashiman as Sempe Stool land. So 1960 between Asene and Sempe ni Niamugitami ni atauna kwa Kwashiman namono. Sanena Traditional Council still in 1966 Kwashima and Sempe mano alo asene mano no na atami ena no koni chwanke na kensani epo ayata. It is the case of the defendants that Ni Amponsa Ankra, the then head of the Abola Piam family and author of Exhibit K series, was among the panel of arbitrators that settled the matter between the Asore and Sempe Stool. So you see, Ni Amponsa Ankra ni at some point, but ni chwaga around like a time leji Abola Piam wekuichwe negisane ni aye between Asore ke Sempe as to who owns the Kwashiman Shikonjiye. Watch a nias as Amponsa Ankra ne Abola Piam ye etami yeko. Refer paragraph 4 of the further amended statement of defense and counterclaim filed by the fourth defendant, the Sempe Stool. In the estimation of the fourth defendant, therefore, the statutory declaration of the Abola Piam family was fraudulently procured. The fourth defendant particularized the allegation of fraud committed by Ni Amponsa Ankra. One of the particulars of fraud states as follows: that Ni Amponsa Ankra was one of the elders who in 1966 declared Kwashiman as Sempe land, but in 1969 produced a statutory declaration stating that as a head of a branch of Abola Piam family, Kwashiman belonged to the said Abola Piam branch of the family. Firstly, I have found Okay, so Uncle get where there triumvirate. Okay, triumvirate. Thank you. Triumvirate. Inukoda. Uncle get judicial Prophet Boy get judicial service tuning down. So elerege sajine pi. Okay, so a group of 3 powerful individual leaders or officials who share authority, power, or influence. Okay, so that's what it means. Triumvirate. Triumvirate. Okay, a group of 3 powerful individual leaders or officials who share authority, power, or influence. Thank you. Thank you. Yeah, me 1 second. Yeah, ni matcha manye real quick. Onu. Yeah, cause me not get no one ne why be so. Yeah, me 1 second. Me buy fight. Abaje. Ege get waga also la di sugar worry. My ege also la di. Ege bote somewhere. So you got worry. My ege also la di. Ege also la. Anyways, all right, let's go on. Once again, I'm so grateful for my wife, man, and the way so I'm so grateful for her. Anyways, let's go on. Yes, I have a jacket. If I will leave there, get also lady. Firstly, I found as a fact that Sowutuom does not form part of Kwashiman, or that Sowutuom is distinct from Kwashiman. Secondly, although the said Niamponsa Ankra was a member of the panel of arbitrators, the arbitration was on the installation of a chief at Kwashiman, and by inference, ownership of Kwashiman. It did not concern itself with ownership of Sowutuom. Thirdly, Niamponsa Ankra did not declare Kwashiman as belonging to the Abola Piam Tumawe family. He declared the Abola Tumawe family of Accra to be owners of Sowutuom. Exhibit N series described the land acquisition by the Ahiaku family from the Sempe stool as follows. All that piece or parcel of land situate, lying and being at Kwashiman, Accra, in the greater Accra region of the Republic of Ghana, and bounded on or towards the northeast by Sowutuom land, on or towards the south of Assurance Stool land, and or towards the west by Anya land, and containing an approximate area of 1,500.267 acres, as the same is more particularly delineated on the plan attached hereto, and thereon shown pink, which plan is marked Exhibit A. It is clear from Exhibit N series that the land acquired by the Kwashi and Yaku family was bounded on the northeast by Sowutuom lands. In other words, Kwashiman lands share a common boundary with Sowutuom lands to the northeast. This description does not lend itself to any other interpretation. Such a description of Kwashiman cannot claim to include Sowutuom lands. I therefore make a finding of fact that Kwashiman lands do not include Sowutuom lands. Clearly, I therefore make a finding of fact that Kwashiman lands do not include Sowutuom lands. The Sempe stool is alleged to be the allodial owner of the land. It allegedly made a grant of all Kwashiman lands, allegedly including Sowutuom lands, to the Kwashi and Yaku family. It is therefore better placed to know that the boundaries of its lands. Exhibit P is an advertiser's announcement appearing on the 24th October 1970 edition of the Ghanaian Times. It was captioned Sempe's Two Lands. The publication was made pursuant to a successful outcome of land litigation in Civil Appeal number 50/66 dated 31st July 1970. Although the title was not specifically stated, reference made to the suit under suit number clearly suggested that it was referable to the judgment of the Court of Appeal in Civil Action number 50/66 in the consolidated suit entitled Ni Yaudwade Crab the third, Ni Ejakwao the second, versus J.A. Kwe of Accra, Ni Tetepeshi the second, Sempe Manche, as co-defendant, and Ni Yaudade Crab the third, plaintiff, Ni Ejakwao the second, J.W. Boy of Accra, Ni Tetepeshi the third, and Godfred Robertson Adiko, plaintiff, versus Emmanuel Joe Akufo. Neke cases nefe ikande pi ehanye. Like I said, anytime ni I make a reference to Sempe Sanie, Sempe Shikonji Sanie, neke cases nefe a cho. So nye menenye follow cases ne ninche nefe nye bana ke efe genakpe ni wabotemi wa denche some of these cases already. Let's go on. Okay, so in that publication, in which the photograph of the Sempe Mancha boldly and proudly appeared, the description of the land affected by the said judgment was stated as follows. Public notice. Please take notice, and notice is hereby given that by judgment dated 31st July 1970, the Court of Appeal Ghana has adjudged the Sempe stool to be the absolute owners in title of all that piece or parcel of land stretching from the Gulf of Guinea to Odoko, from Kolegono to Sakumo Lagoon. Before. Attached to that publication was a judgment plan which shows the extent of Sempe's two lands. The defendants in their pleadings depend on this judgment as one of their arsenals. That they depend on this judgment to show that Sowutuom forms part and parcel of Sempe's two lands. By the publication in the Ghanaian Times newspaper of Saturday, 24th October 1970, the Sempe Manche Nitatekpeshe II announced with the aid of a copy of the judgment plan in the litigation between the Jamestown stool and the Sempe stool on ownership of the lands in Accra West that the northern limit of Sempe stool land is the Winneba Road. So once again, the northern part of the Winneba Road, the Jemejeni Sempe me ameshikon GFM muonaye. Anything you were J Sempe mashikoni dom. Nowhere in the judgment plan was Sowutuom indicated. Indeed, the Court of Appeal suit under reference concerned a piece of parcel land described here therein as being at Memete, and from the judgment plan, Memete is indicated as being by Latabi Okoshi. Sempe stool lands were described as being to the south of the Winneba Road. The Sempe stool and the first defendant cannot be heard now to say that Sempe stool land extend beyond the Winneba Road into Sowutuom. And I take judicial notice of the fact that Sowutuom is located far to the north of the Winneba Road. I make a finding of fact that the Court of Appeal judgment in Civil Appeal number 50/70 Exhibit Q series did not concern Sowutuom lands. Anyway, Sempe be evidence I may adduce in court, thinking I can no help I'm a case. Instead, that actually went against their case. So clearly, everything this Sempe may produce neke case name here, their own evidence now may adduce fair went against, like it went against them. Nothing actually supported. I mean, evidence now make a bar. Quote and unquote nibi now make a bar. Now me lench I may adduce it didn't push their case at all. It actually destroyed their case. Again, the said publication may be regarded as an admission against interest. There you go, admission against interest. There, ni wakane Eliana, a court authority go from London in 1912. Benye kayo, ake keji moko admit noko against ledienche here. You cannot say ake anonimo admit is false. Remember earlier on in the judgment. No, jinoni ayue. Again, the said publication may be regarded as an admission against interest. The admissions against interest by the Sempe Manche by means of the Ghanaian Times publication is binding on its predecessors and successors, including Ni Adote Oboa II. See the cases of Shat Ache, another case. Now we'll move on. What Chale Bambang Agbene, appellate court ruling Agbelo. I'll see what we're going to do with the appellate court ruling. We'll just go straight into any judge. If I'm, but I cannot read it all. It's an bring program to an end very soon. Furthermore, the publication rebuts and effectively negates the claims of either or both the Sempe stool and its alleged grantee, the Ni Kwashi Ahyaku, to Sowutuom lands, which is to the north of the Winneba Road. The Sempe stool elders, as experts in Sempe traditional history, cannot reconcile the Ghanaian Times publication with the Sempe stool and first and second co-defendants' claim to lands to the north of the Winneba Road. So, Mofemo, ke otaunyo le ene Sempe ameshikon na gboye the north of the Winneba Road. Simple. And then ayo inchobi. Sempe ma shikon ene gboye north of the Winneba Road. It starts from the Gulf of Guinea. So babo inshona. Niji wo inshona. Bona. Ke ata the north of the Winneba Road. Anything after the north of the Winneba Road there, Sempe man, Sempe man should not be claiming anything there. Ona bonin here yo. The Sempe stool, it is hereby conceivable that the Sempe stool elders who taught Nitetekpeshi II the traditional history of Sempe would not have known the full extent of Sempe stool lands or of so crucial a historic event as the alleged grant of the Kwashima land by the Sempe stool to an Ewa man called Kwashi Ahyaku about 200 years ago. It is the plea of the fourth defendant, refer paragraph 6 of the further amended defense and counterclaim filed on the 19th of October 2012, that 6. The Sempe stool will contend at the trial that by virtue of the Supreme Court suit in number 31/81 consolidated, entitled Ni Yao Duade Crab II and Ni Ejakwa II plaintiffs versus S.A. Kwe and Ni Tetekpeshi II defendants, dated 31st July 1990, affirmed the decision of Akolache, dated 10th May 1963, that allowed their title of the Sempe stool in the Kwashima lands. Once again, Noni Wakandie, J. Nakaini. So everything that the Sempe people presented in this case, it actually went against them. Every single thing. I've so far not read anything that supported Amekese. None. Unfortunately, I'm unable to accede to such a contention. Once again, this is the judge saying again. She is unable to accede to such a contention. In the first place, and as stated supra, the Court of Appeal never made such conclusions. The court did not affirm the decision of Akolache, dated 10th May 1963, affirming the allodial title of the Sempe stool in Kwashima lands. As noted earlier, the land in dispute in that case concerned land located at Memete. It is misleading to state, therefore, that the judgment of the Court of Appeal of 31st July 1970 affirmed the allodial title of the Sempe stool in Kwashima land. So, you know what? This Kwashima land, Iliake aye Sunday. Iliake aye Sunday. Born after Neke Sanjine. She Kwashima land selenche. Asene me baye ege Sempe baye akoti ye. Ni tete otawo trouble. Unless aye Sunday between Asereke Sempe ye Neke Sunday ne. Bona ni I declare full yake Sempe mano. I don't know. So don't take my word for it. Shikeji ayeko Sunday. Ye Kwashima Neke Sunday ne ye. Ni get clearly as to who owns Kwashima land, say no one is not set in stone, it's not fixated. So can send me still, I'm in town, I make claiming ownership to Kwashima land, say they can still take Sempe people to court. Aguje, actually, I'm money, and you don't go be But once again, don't take my word for it. Maybe there are other cases, ni aji. ni a call Kwashiman Sunday between Asare ke Sempe ni a declare ke Jeme Sempe ma shiponi. She keji ajeko Sunday kokla ni just agne keke ni ball Sempe me koje me keke. Once again, clearly no what can even as to Monet Sane to Manche Jeme Jajen Kewake 1966 say Nakansane Boye Agbena. The traditional council make bena. That is what the judge is telling us. As to money between us saying Kesempe money sane to manche kwashima. The traditional council na ametano poe. I make bena. Na kanja ke. The court did not affect. Okay, let's. It is misleading to state therefore that the judgment of the appeal. The Court of Appeal of 31st July affirmed the allodial title of the Sempe stool in Kwashiman lands. Come on, you here. I can again 1970. You cannot say ake judgment affirm me ake Kwashiman shiko Sempe mano. This is what the judge is saying in 2017. I mean, this was in 2014 before it appeal say. You understand? So 2014, just 2014, no, Sempe, you cannot even claim you have a loaded title to it. 2014, just 2014, this is what the judge was saying. Once again, KG after 2014, after 2017, I don't know. She can't send me come and town and challenge Kwashima. They can. Judge ko me opening. Jaja ne taneke sanene no send an opening. In any case, I have found that Sowutuom does not form part of Kwashiman. In his address filed on the 12th of March 2013, counsel for the defendants accepted his portion when he stated at page 13, paragraph 67 thereof, that in the Yauduade crab case, now, I swear people should take them on. Hey, Uncle John, hey, I swear we'll lace up our boots and head to the court of Kwashiman. I can become chief of Kwashiman. He emphasized this position at page 14, paragraph 68 thereof, when he again stated, it is submitted that in the Yauduade crab case, the lands in question were the Sempe stool lands in Accra, whereas in this action, the lands in question are the Sempe stool villages. The judgment under reference never made any distinction between Sempe stool lands in Accra and Sempe stool villages. It is therefore clear and an admission on the part of the fourth defendant that the Yauduade crab case never concerned Sowutuom. Exhibit Sempe stool 7 is a ruling dismissing an application for interim injunction brought by the plaintiffs in the case of Peter D. Quarty and two others versus Ni Late Kwashi Anyaku and another, suit number L14/1982. In that case, the learned trial judge dismissed the application based on certain stated reasons. One of the reasons being that A, the defendant is at least the de facto manche of Kwashiman. So I dismiss it again case. Who prima facie is entitled to the grant of Kwashiman lands, and greater hardship would ensure to his stool if he is restrained from interfering with the lands. The fourth defendant in paragraph 8 of its further amended statement of defense and counterclaim filed on 19/10/12 stated, by and under the ruling of the High Court, in the case Peter D. The court stated that the de facto manche of Kwashiman had a prima facie right to make grant of Kwashiman lands. Okay, let's go on. This is last but one page. So I think I get manyesha could be a wanya work appellate one fitai. Again, one muna nyongulu. Bona. This is a first statement of one of the reasons for dismissing the application. However, as I've stated in this judgment on countless number of times, the issue in this suit concerns the ownership of Sowutuom lands, and I have made a finding that Sowutuom is different from Kwashima. The issue in that case involved Kwashima lands. Secondly, Exhibit Sempe 2.7 is only a ruling of the court. There is no evidence on record that the matter was finally and effectually determined. You know, there is a difference between a ruling and a judgment, right? Rulings say usually kenoko call sandiko ni aye and judge by rule okay on this on this you understand what I'm saying? So it is not the same thing. A ruling and a judgment are not the same thing. A judgment actually talks about the finality of the case. Bona, it talks about the finality of a case. Bona, now, in between the commencement of the case and the finality of a case, where any judgment baba, there may be several rulings based on nibi komeni aje yet nakansani no me. You understand what I'm saying? So no judge feel clear biake noni ayuene it was just a ruling because ena ke sani put enche agbena because ena ko judgment based on nakansani ni aye ni ayuo ye bi. All right, so let's go on. The issue is that the case involved Kwashima. Secondly, Exhibit Sempe 2 is only a ruling of the court. There is no evidence on record that the matter was finally and effectually determined. The suit therefore carries no estoppel effect against the plaintiff's hearing or the plaintiffs in the suit. See the cases to another one. Look, the case was not brought to a finality in itself. So it was just a ruling, it was not a judgment. A ruling differs from a judgment. A trombo case in a case go what a ruling, there you have it. So let's just move on. Based on the foregoing, I make the following findings. The Sempe tool. So Agbena, this is the final page. Appellate one. Based on the foregoing, I make the following findings. The Sempe tool is the allodial owner of all Sempe tool lands, including Kwashima lands. So but look, grant an opening. If they want to take Sempe on, they can actually do. Because nakan judgment tennis Sempe may rely on a judge no declare whatsoever. Ake Kwashima is for Sempe. Agbenenwe nakan sania na aye as to money is an to manche ye Kwashima between Sempe ka sen nakan sania aye agbe na ye traditional council brother. But nibi ni judge deciding based on nibi fe na ke we the Sempe tool is a lawyer owner of all Sempe tool lands, including Kwashima lands. Okay, yes. Kwashima efita shikoji ni Sempe me amamenoni. Kwashima lands do not include Sowutuom lands. Kwashima efita Sowutuom hi. Solo Kwashima the solo Sowutuom. The Sempe tool is not the allodial owner of Sowutuom land. Nebu abi ku. So this is where it is. No ni wakani efe ni one town nibi efe no ni wakani efe ni one town. Wamuna none. Number 3, everybody can see it. You understand? Everybody can see it. Everybody can see it on the screen. You need to take care. Number 3, the Sempe tool is not the allodial owner of Sowutuom lands. Number 3, everybody, there you have it. There you have it. Sempe me fe Sowutuom je noni. Sowutuom efita Sempe shikoji ai. Mo fe mo aka number 3. Ko ye Sempe o je Sempe yo kwami. This is number 3. Number 3. No ni kan la ne fe agbena. Number 3. The Sempe tool is not the allodial owner of Sowutuom lands. Agbena. Finito. Agbena. Bona. Agbena. Again, I am satisfied that the evidence led by the first plaintiff and supported by the second plaintiff proves that on the balance of probabilities, the Abola Piam Tumawe family of Accra is the owner of Sowutuom lands and therefore has the right to make grants of Sowutuom lands. Sempe I am satisfied that the evidence led by the first plaintiff and supported by the second plaintiff proves that on the balance of probabilities, the Abola Piam Tumawe family of Accra is the owner of Sowutuom lands and therefore has the right to make grants of Sowutuom lands. The plaintiffs have been able to discharge the burden imposed on them by law. They are therefore entitled to their claims as endorsed on the writ of summons. Having declared the first plaintiff owner of the land in dispute, the activities of the defendants amount to trespass, and the first plaintiff will be entitled to damages for same. The first plaintiff is awarded general damages assessed at 5,000 Ghana cedis against each defendant. The counterclaim of the defendants fail and are hereby dismissed. Judgment in favor of the plaintiff as follows. Declaration of title of the disputed land in the plaintiff. First plaintiff is to recover possession of the said land from the defendants. The defendants, their workmen, agents, assigns are hereby perpetually restrained from entering the land in dispute or in any way interfere with the first plaintiff's enjoyment of the land described in the statement of claim. The court award damages of 5,000 each against defendant for trespass on plaintiff's land. Defendants to be surcharged with the cost of removal, cost of 10,000 against each defendant. Counsel for the plaintiff, Peter Zwinis. Oh, yes. Peter Zwinis. Okay. Counsel for the defendants, Colonel S.A.S.M. Asante. Peter Zwinis say Bolly, J. Shomo lawyer. So Abola be they really had a good lawyer. So Tamoboni Kebwe ni aye case in our time. Sempe me amekpene ni amekete appeals court border. So nyani what go through now. Tumoboni olie appeal is by way of rehearing. So because of time, I want us to skip DBNE about UAF bona. We will go into any judge can here bona because Manye should be here very soon. No nyani wake appeal no afetahi nyonglo ona boni ni here. So what can they here because tomobeni nganye feel da ne no can yenye ba no ni bi any aye na me api about it's like you know appeal is by way of rehearing. So you already know so let's just bring that up. Ni will go into the details. Bona ni just one muna. Yeah, Jimmy. Okay, here goes the appeals court. Like nyeleboni you kano go ye ni sempe me ba kababa na me ba sumo ni makande engineer ade to tinto ball leboni fiole kan wonu ende kan mi bona kon kan o kan akuche no to mo boni ni so fele akuche ka mi ka osumo no ko ni makande ane she akuche de ke sha akuche de no ni ne ba she no bona. So I hope you can see this. It's a little faint, but so okay, okay. In the Superior Court of Judicature in the Court of Appeal, Accra, and so May 8th channel, Judge said I'm a form Korame, I'm a GFJ Kobie, presiding judge, Agnes Dodje, Mrs. Mabel M. Ajuman, Mrs. So there you have it. So as you can see on your screen now, the same players. Kingsford, Ajaben, Michael, Agbawelefio, and the Sempe too. The same players. Same players. Versus Seth Ankra, ke Joseph Yaya Adi. So Sempe me ke defendant na ya me amekpene ni ama make case te appeal. So like I said, a lot of these obanu can defend about your original name, you know. So for the purposes of time, I must skip ni waya any judge going you. And of course, it deal with some technicalities, but let me skip that. I've been reading for 4 hours, so let's move on. Yep. Okay. Any it make a little sense. Like Konega fit what jump too much. Okay, so 15 pages, right? So this is what I'm going to do. Let me read. Let me read from the 7th page. Bona. Yeah, I'm trying to. Okay, so I'm just gonna run through it, Bona. So bear with me. Let me run through it. Giddy. Producer ke just in ya any judge way and in candy jeme pe. Let me see. Okay, let's see if we can do that. After so I'm trying to see after nijeje egbasani efen agbene ene bon iwe mo keje, and of course that will not be on the last page. Mita ni work can no nijeje iwe before he arrive at Exhibit A series were tendered without objection. Yes, so yes, okay. BFN, UFN, once again. My page share. Okay, let me read from page 10. Bona, it's 15 pages, so I'm coming from page 10. Koni, we'll put a little bit of nina to it, a little bit of flesh to the reading. Bona, instead of okay, so so the plan attached to the document locates the land at Sowutuom. Even though the learned trial judge commented on the probative value of Exhibit K, each narration of historical events was not challenged by the other side, and therein lies its value. For instance, in the case of in R.E. Ashale Boche lands, Ajete Soa and others, versus Kote and others, 2003-2004, Supreme Court Ghana Law Review 420, the Supreme Court held that generally, statutory declarations per se are self-serving documents and so of no probative value, where the facts contained in them are challenged or disputed. Exhibit K series were tendered without objection, and throughout the cross-examination of the first plaintiff who tendered that exhibit in evidence, there was no challenge or dispute as to the historical account of the first settlement by the Abola Piam family. Once again, question ni what plaintiff say in this case Abola Piam, I mean chon bonife na be ba jejeme na kan no a challenge. One can therefore say that the legal principle enunciated in the NRA Ashale Boche lands case supra is not fully applicable to this case. As opposed to this evidence, the evidence of ownership of the land in dispute was given on behalf of the fourth defendant by Ni Adote Mofat. See page 267 of the records of appeal. According to the witness, the Sempe stool is the owner of these lands. The Sempe people were the first settlers. They were also farming there, hunting there, and the people came to them and they gave them land to farm. It is only Sempe Manche who gives an order before a land can be given to the people in the villages to farm. The witness was, however, emphatic that the land is situate and lying at Sowutuom at Kwashiman. See page 265 of the records of appeal. So we proceed to consider the next issue, which is the issue whether or not Sowutuom and Kwashiman are one and the same geographical place. The trial judge made a finding of fact that the two places, namely Sowutuom and Kwashiman, are different. According to counsel for the defendants, the trial judge made her finding of fact only because of the fact that the defendants, particularly the first and second defendants, had amended their statement of defense and moved from the initial position that the land was situated at Kwashiman to the land being at Kwashiman Sowutuom by the first defendant and Sowutuom sometimes described as Kwashiman by the second defendant. The Honorable Learned Judge arrived at a conclusion purely based on inference, which is inconsistent with the direct evidence given by the defendants. It would have been very useful for counsel to have followed up immediately with the direct evidence adduced by the defendants that he is talking about. As it is, we combed through the record of appeal to try to find this direct evidence that says that Sowutuom and Kwashiman are one and the same place. On the other hand, the plaintiffs have always maintained that the land in dispute was situated at Sowutuom and not Kwashiman. And the second plaintiff had made grants of similar lands to persons such as the Catholic Church and the VRA without any challenge from anyone, including the fourth defendant. In any case, as pointed out by counsel of the location of the land in dispute, she had not resolved the issue of the ownership of the land in dispute. See page 438 of the records of appeal. Besides, it is a notorious fact that Sowutuom and Kwashiman are two separate and distinct places in Accra, although adjacent to each other. We therefore take judicial notice of the fact as the trial judge could have done. Counsel further contended that the trial judge said that the fourth defendant never challenged alienations of the land made by the second plaintiff, but that the assertion was contrary to the evidence on record because even the witness for the second plaintiff had conceded in cross-examination that the Sempe stool challenged the Abola Piam family in court over a grant of land. Counsel for the plaintiffs, however, countered this with the argument that the kind of challenge envisaged by the judge was a successful legal challenge that resulted in a judgment or order in favor of the Sempe stool. As we have ourselves pointed out above, there is evidence on record that the Abola Piam family has made grants of land next to or close to the disputed land to the Catholic Church to build a seminary and to the VRA since 1979 or thereabouts. But the Sempe stool, and for that matter, no one else has ever challenged those grants. We therefore agree with the learned trial judge that since making grants of land is an incidence of land ownership, we affirm a finding of fact that the land in dispute is owned by the Abola Piam family. Following from all the above, we dismiss grounds A, B, and E or additional grounds A as being without merit. So, appeals court be a kage. Look, Sempe me she Abola Piam be I mean kage. Look, ena your shipon sandi ena your Sowutuom ni shipon ni. Ni Sowutuom shipon ni ama Abola Piam bi ama me no ni. I make a grant me. I make a grant to the Catholic Church. I make a grant to the Volta River Authority as far back as 1979. Mogomokwe challenge ko these grants neni ameke ha neke mene ameke ko yan government mogomokwe challenge ko Sempe me challenge ko asele me challenge ko mogomokwe challenge ko ni akeni shipon grant mo chon money ono shipon no elebe eke cheje ni yesani enkpangbe ake lele ake shipon Abola Piam bia no ni noni Sempe me sanye na mekeba ni grounds A, B, and E or additional ground A jeje ke ewe chafun because grants na Abola Piam bia ke ha mokomoko challenge go these grants no chwa lele shipon amame noni. We now come to ground F or additional ground B. It reads as follows. The learned trial judge erred in law when she held that the single publication in the case of Niya Duade Crab III and another versus J.A. Kwe, others, civil appeal number 50/66, stops the Sempe stool from making any claims of land outside the confines of the adjudged area of the said judgment. It is the content. Remember, Akashi. On ake Sempe me ame koto neke ya Duade case ne neke ya Duade case ne no na dumo na ko ake echon na ameshipon na agbe it only goes as far back as the north of the Winneba Road. Anything else outside of the Winneba Road they cannot claim anything ya jame Sempe me na mekete apila me kage dabi na kanjeje nye yu na kake neke juno ni ya Duade krabe ke amekele pa agbe ake they cannot claim anything outside or beyond the north of the Winneba Road. They cannot. So no, it is the contention of counsel for the defendants that the conclusion by the trial judge that the Ni Duade case constituted admission against self-interest on the part of the Sempe stool was an error in law. Counsel, however, failed to expatiate on what constituted the error of law. He argued that the judgment in the case at the planned attack that did not include Kwashiman, Sowutuom lands. As pointed out by counsel for the plaintiffs, counsel for the defendants is blowing hot and cold. He cannot approbate and reprobate. It was the fourth defendant who pleaded the Ni. Fourth defendant, remember, in that case, was Sempe stool, who pleaded the Ni Duade case as showing the extent of its length. When therefore the trial judge made a finding of fact that Sowutuom was not part of Kwashiman, she took that very judgment into account and declared that the fourth defendant was the allodial title owner of Kwashiman lands, but not of Sowutuom lands. So wherein lies the error of law committed by the learned trial judge? Once again, I cannot no you of look. Can you Kwashima and no me here will me lele Kwashima and yenoni? She Sowutuom no le Sowutuom ele Jane yenoni. Jane you know. And once again, like I said, look, Aseneme can still test the law on this Kwashima land, say, even though the trial judge at the time, noni Sempe may claim okay, Kwashima, you know, she can okwe na can case or Dubai, kaji any quote again, like a bebe ne quote me. Aseneme can still test the law on this Kwashiman, Sanjine, they can test it. They've been given an opening. The trial judge's pronouncement simply followed logically from an earlier finding that Sowutuom and Kwashiman were two different geographical entities. Having acknowledged the rights conferred on the Sempe stool by the Ni Duade case, the learned trial judge pronounced it the allodial owner of Kwashiman lands. But having found that Sowutuom was not part of Kwashiman, she was perfectly right to have declared that Sempe stool was not the owner of Sowutuom lands. We see no contradiction in those two declarations. This ground of appeal will also therefore not see the light of day and is hereby dismissed. It will be noticed that so far counsel for the defendants has argued only on grounds A, B, E, or additional ground A and F, or additional ground B. He made no attempt to argue ground C of the original grounds of appeal. The law is that in such a situation, the defendants / appellants are deemed to have abandoned the ground of appeal. This court therefore considered ground C as abandoned and nothing more will be said about it. Following from all above, the whole appeal is hereby dismissed as being without merit. Signed, Francis G. Corbia, Justice of Appeal. I agree. A. Doji, Mrs. Justice of the Appeal. Mr. M. Ajima, Mrs. excuse me, get Mr. M. Ajimai, Mrs. Justice of the Appeal. I also agree. So they lost 3-0. Once again, counsel, Peter Zwenis. Peter Zwenis is a fantastic lawyer. Of course, I'm not surprised that he won this case for the Abola Piam family. So there you have it. It was also I want know a chafo. So look, when it comes to Moboni, what discuss no nani what can the High Court judgment, appellate court no one can have you need to know. Okay, look, Sempe me, I'm a beshipon. Yes, you too. I'm a beshipon. Yes, you too. And this Sunday was in 2017. So why are we still? But in Canadian, so I'm a Facebook biane. Why are we still doing this? Where any individuals, I'm a representative of Sempe stool. I'm about fight Mokoni Abola Piam yeto. Look, no matter what ni adoto tinto by you, don't buy it. I've shown you the evidence. Look, the Sempe stool has an interest here, Jimmy. You understand what I'm saying? And so, okay, in 2017, I still do not understand why ni nekenoko ete no yebie. You understand what I'm saying? Now, let's see if we can get Mr. Ankra real quick. Ake ebanye kenoko fio afitai eha walo biamini wo me manyen. Let's see ake when they bashe Mr. Ankra nolo. Let's see.
Hello,
Prof. Over the board manye.
so me never know.
You what dromo ofane
Almost 3 hours.
I know, Bolly. And make our mommy ele
Well,
what
so I
can
look at you fan na kaino.
That's right.
Todo.
That's right.
Me me phone la work every. Dr. Jesse Ankra. Go Basani Kennedy.
Yes. That's right.
Yes.
That's right.
Well, no work every fiano.
That's right.
Chuna, when they say how gajo Any me how gajo. Ni jo no ko akọ ukabo no. Patapa. If they go. No come on now. Yeah, especially God Traditional Council. National Minister Jalemi can call me Gabajo.
That's right.
Come by your son, Jale can call me. Intini and Gane, face a baffle. The bishop boy, a woman change. Lady Brittany, our man change to money. Manya Sowutuom.
Atomanya biade. Oh, meji better atomanya Sowutuom.
Oh, Mapaka man and for you, can say the book.
Yes.
Now, I say, Ashalawo, Gun Central Municipal Assembly, as a member.
Oh,
Many of you, many big anime. Many big anime. How? Yes, Ashalawo, Jemmy. Ashalawo, Jemmy. No, for the Mapaka and Biam, look at that. If you know, much coming here, you can send the book.
Yeah, often can send me. Yeah, it's an in take care. You take care on. It didn't be a show on this old chief. Yeah, because yes. Yes, so an in take care on. Yeah.
Yes. When you be Peter,
right.
Peter. It's a Peter's one.
Yes, right.
Yes. Yeah. What take on?
Yeah, you have to. Yeah, you have to.
Yes.
Because cannot fair say and still I mean to Magnolo as you to I mean, come on, man. I mean, what are we doing? I mean, this is crazy.
Yes.
This is crazy. Yes, it's an in your take on.
Yes.
Yeah, it's an in your take.
Yes. Yeah. After any say I say just it. Kelam Commission assign memorandum of understanding. 2018.
After the anything. Each of an Sanoka no one sending me. Sanoka no one sending me. That's right.
Chipo New York, not all Tabora, number 1, number 2, can be Israel fake can be. Abola Piam Chipo. Example, the corner cafe Olympic Sports Stadium, then you know. I don't want to make a man, you make a Safra Chemi, Capashi. Capashi. You know, Ottawa. Gajo. When we got tradition cast and a little money. I make a quality for an quality car. Come for them, Guy Joko. No Bashi wire, or be or not be. Yes. Come. I believe economy near me about near young crack any.
That's right. Yeah,
let me not be any day. That talk was going to hospital you come honey.
I see.
Then you know. Yes. Then you know to body the young crack a boy. On a knee. She never barely can only do the Aposanka war. The Amamano. The Aposanka and you look by in your way.
That's right.
And you only family head your way. It's a cotton.
That's right.
Ona, you come and tell history. I'm not by history. Look at my history. You got Joe. Again, what's had done? You wash your way. You wash your way. No matter how you come at you. The Greater Cote family lawyer.
Right.
Then Nakahan Land Commission. No woman didn't make a memorandum for the standing. Nearly back on small Jeffrey after Jihame. How come? Come at you. Let's take a Land Commission. For next 2-3 years. And now or 2. You may.
Yeah, but Landlands Commission has sending you. I know. Yeah, it's a lot of money. I know. Yeah.
Yes, a lot of money. Because you know, I don't carry it.
That's right.
I find a man. Government Chicago,
yeah.
What I mean, Government Chicago, Germany, no bad mistake can be no time you go to court. The Land Commission, Amida. Oh, say about come by Amida. Amida. Can't have judgment against them. You government Chicago, no papi. That's their money for me.
Yeah.
Money for me, Kutukumi. No Germany, Sammy.
I'm a mesh, come you.
Yes. Maybe money. Well, community matter kwa majibu. Any join tete question for me. No gente friend. Akuma je gas mo yemi. Yes, 1970. Akuma je gas mo yemi. I'm at the West African Court of Appeal. Yes. Akuma je tete. Well, how more refined share how more back. No kwake ma any be am no kwa majibu.
Ofane yompa. O
I'm not of you.
All right. Thank you so much. Thank you so much. Anyways. All right. So yeah, all right. Chebegeme, Mr. Ankra, Legi first plaintiff ni wana ye neke noko ne mi lawsuit ne nkane habone. Legi money wanu ne nyama twa that audio for you. Ni Dr. JC Ankra make le plain ake that the bana be amebeno ko klomo. Yes, you too. Let's go.
Ke otao okunko adakuwe Abola Piam amame nomini neke Abola Piam emi jeme mi ini aponsa Ankra enyawo ni fole jemeje ikafe nyehie ya akeni aponsa Ankra eba ye Abola weku enonupa echejo tublo ye dade bana shi enyawo hewo eye onupa ye nakanshia emi kwamo wojiami le mo efan Abola he ojogba he mi ni aponsa efa abola he ojogban ene no chon enyeme ni jo tublo nke ake e awo otublo nshikpo eke ake abola shiamele amele na ka jeme no tublo biye yuo amele ona Sowutuom abola amame shikpo ni otublo nko no ko eje gbemi beni ayiwaso le enomi nfe eji na ka jeme no mi etaflache ngbo tublo mpoyo shi ini ba fa no ni jijale kanu kwale yue moye eha no ni ji abola wo okunko adaku jatawe je mena keje ifata fantasia ni yo abola jemele ayiwaso le nomi mpote jina kan jeme ye amini nye yuradon solo okunko adaku jatawe ni solo atwei ipeleno na kanshia ka cha atwe pege ma ingbe kami ya agbe teshi na ni chie enyawo ni fole ejo okunko we she aye manje ye teshi e fagai kele kotokumi shika gamenya pele ene baha akele ni chie enabi afe manye kona ake daleshe tomo boni ake dentist coffee ni baye Jamestown manche ni wo chele ake ni achele mi ni obrempon kojo abebi o enyawo ke ehaw na shika eke fa Jamestown anya pe yo wo be sana ke eyo na musumimbi atole manche kuna ke dayo nation afi kodan ake ka set precedence anyo a follow wo ni chie echeje tashi hyenye Abola Piam ene ba na atwei ne ke ake na ke be ekpleno e no ko ewo kwesani gama ape nu niji ni chie ni ya itashi manje yo kenye ba wa bie ni kase mo ye ni sani wo kase.
Right, so there you have it. Dadebana be ingba inye mejinye nyebe no go club with Sowutuom agbla mi anye. If you don't know the history, there you have it. You guys have nothing there. Nishi Abola Piam in be and I cannot understand how ni I've asked for it text wache komeu ni send me something of this alleged installation of Sowutuom manye ni afele recently. Look, you see, if this is indeed true, unless ekole ni adoto tinto ole eko shike ole eko pa, I mean, come on, sir. Really? You really going to do this in the midst of everything that is happening? Really? Nje? Really? In everything, in the midst of everything, you know, once again, I'm just saying, if only, ekolole, negolole, baby again, you ain't be a call me again, ole no fair no. But I like to give you the benefit of the doubt. I mean, you seriously going to do this in the midst of everything? But bench, because she don't change you know. In the fact I can manche no fit I can no go neba. So to go ahead, ni abasa to manye. Once again, allegedly, maybe this is not entirely correct. But if it is, come on, man. In the Gano Tower, no Samoy. I don't know. Because ene je ga samoni. Ene ga patomo, ga fitemo, ga dra. In the midst of everything that is going on. They can some money. Because small Jane no ni. And once again, that is why I keep saying, call Abola Piam, go back. Help these people. Help Mr. Ankra. Help them. They need money. It's going to take a lot of money. Fighting over this. Jane no go be a lot of money. Clearly. Shika efia unto. I mean, it's ridiculous. Okay. I mean, it's still one man. Now what try Uncle Johnny real quick. Okay, I can squad Baba no look. Okay, Uncle Johnny. Hello, Nje.
Hello.
Oh, no more. Me no gay.
Hello.
Yeah, impa. Oh, yeah. Oh, no way.
Yeah, I mean, we need to prosecutor general.
Yes, sir. Yes, sir. Yes, sir.
When the judgment no will never to go back.
Oh, no, hey.
Fine, I mean, I'm fiamo.
That's right. We're able
Mean that man, she work and no fear, no, she how.
That's right. That's right. That's right.
Baby boy, the whistle in your no, the baby 1 year came in.
Ayolo, no, Ayolo. That's right.
Only no go. Owieno ko ne domi. Edomi wake Joseph ni Yaya Adi ejemi. Si ebomoden wae Abola Piam.
Yes.
Ke wo show nupa enye kansi ne ke na me banya me domosin. Na menu shi ke sipon je amame no. Sipon obeni ofori atagwe ke the land belongs to our ancestors, those who are dead and gone. Those of us who are living and the unborn. Over the manu
yeah.
Ke show nupa na kan wo sipon je ahon le tomatoes.
That's right.
Come on, behave like a personal property. She come no more no fun amesipon no more bomodin wa denje. Domi wa ke be alive to hear me congratulate him.
Yeah.
No more akon le heko papa ni ewo.
Yeah.
Matu fun Jesi ankra. Enanko akane no ko your program no until ba apologize.
Oh.
Because what two resource person here by Jenny Ketche your platform no
That's right.
Or until number blame ambadia me is a number blana kind of nibia number wish you often I mean what's also swing that
That's right. That's right. That's
right. Come on ni ya no ona nko ba ke cheme bega who wake Wayeboni o Sabune, you are an illegitimate chief, yes, Sowutuom. I don't want to believe I may know some woman. But no near say Buffet, correct more.
Yeah.
I get your Ganyoni. Now about what a man say be a name.
It's crazy. It's unbelievable. Yeah. It's unbelievable.
New Tabu is illegitimate. Yeah. For the first time, I agree with you. You don't have a problem with your regular contributors. No, but I disagree with you. When you na akaka wo Sowutuom and from Sempe no sana pole. It's an illegitimacy.
Right.
A bel legitimacy. Sane ta Sowutuom se konwake manjeng meneke wo.
That's right.
At all. The land commission last seven cable, Sana Gale.
Yes.
Land
absolutely.
Cafe, ye Ghana, ye Gamasipono. What enough we have 100 cities, so they Capos, Central Region, 100 cities, so Shantepo, 100 cities.
Be a committo thousands of cities.
5 cases. Can you imagine the number of people near Memphis searches on their land? Wabaka kame sipon die fe sikana me fi ofen gama sipon e won lan komi ne e wo fe komi ni wo ba dale wo he jonwo.
I agree.
because people are enjoying from our toil and from their sweat. Come on, only Shippo na ya hey me kuma onye nya for say the connection be so me ete nye record minute da nye to nye wo gamate be da na me to na ame wo wotem be and then they benefit from the chaos. You can imagine the number of searches now feel every day. Now, 1,500, 1,500. It was now was Sanjiana. People will not be enjoying our toil and our sweats. It was Sempe Manche. One pabo fight. Nibi Cometino. Clearly. No, that's Sempe. Personally, you might not be involved. Maybe no blame as long as Ota Sempe to learn, no, you cannot resolve this issue. So no, choose clear case of conflict of interest.
Right.
Step more aside.
That's right.
Now, mama, I'm not independent because we in the light of all this judgment,
Nah, it's unbelievable.
Bad boy into money. How? Yeah, akpotoga how you work money prof to an extent I agree. But this is the time this not stop me. When you was council it's become one complicated my life too much.
That's right. That's right.
Washing inheritance papa ko ha me na me ka me ba benefit one to na man no Don Diego Diazambuja maybe a man na me yina
That's right.
In the palace for Madan Kebaho Langma Wole amefe over king kenyemefe amefe
That's right. That's right. That's right.
Amen to too much.
That's right. Anyways.
Okay. That's right.
That's right. All right. Thank you so much. All right. Bye. Right. Okay. So money in Kalegme screen there no ni onabiane. I've been told that I'm being told that no more folie enyemi yodi. I'm being told that no more folie enyemi yodi. Ona manye na dede akle the first. Sowutuom manye. Near the totinto. This is a big no-no. Look, you are. It's like you don't appreciate the sort of power that you have. This is a big no-no. This is a big no-no. I can't get no more for you. Enyemi yoni. MC ne yo na kankukpa no eje Sempe. Niado to tinto aga eje Sempe ni bo ona anyo wani. Ona anyo wani. I'm in Tabi and me receive information here. Na ke picture I'm aga dibi fitai. I mean, come on, man. Come on, man. Why? If you want people to believe, okay, you really mean good. You really mean good. Clearly, come on. But we'll deal with this sometime later. Nyani mashianye. Nyefenye yi anawalada mindanyeshi. Ake was spent that's almost 5 hours. Ni wahimbie. Thank you so much for everybody. Ni eba join the war. Of course, we'll about take a break. Monday, Tuesday, we'll be here. Wednesday. I would love to start with letter and receive it from Bese the quote and unquote Jase my build case about this same cheme I make my letter code before, I mean fair press code before. So I would love to start with that. Koni man be a fan. What were you are no quality or take his sides. I will check what is good for the Jews is equally good for the Ugandans. So now. Anyways, thank you so much and happy Mother's Day to everybody once again. Ajo nyefe wabaku se wababa bieko but in between time obana ngakuche video bagmeno wo ehabo wo sele makwakenka akuche efe video say nyo no nako. I'll try and see in Kenoba. Agbene aduma. So asani week na mi nkeno ehabo. Cheme fe shianji fe na aduma ma compile fe komi ni nkeno ba abo. So we'll do a show on this. Okay, so NLA is this from us? Okay, okay, all right. We'll deal with this. I'm still getting stuff here. Yeneke manyene sane. Bene nye clearly. Je Sempe bene. Na dede akle. Na dede akle. I don't know, but okay. Yes. Yeah. So we'll deal with this. Chemeka jeme. Bona. Nyani wakpa. Ingemanye boli. Wabajikbu. So we'll get back to this story. Inje ni adoto tinto. Kenogoni nu shishia lo le no ko ye ne ko yo fani. Ani akuchale ka kuchele ba kemi. Bona keke no ne sani ma ke man bi emba ke man bi, but this is a no. Ene man dwani. Ene nifite money. Ene ofitega. Right. So between Boka Seneme, I really don't know. You understand what I'm saying? But it is what it is. I'll see you again. Let me say this. Kote gomi no afeno ko oba kajeme. Nyemeni ya gomi. Trust me. Ninyo sumo gomi ona. Akanye ba wade kani. Na ba klanye na akanye ba wo benyelebo akanye ba wo shikpo na ba lo shi ahwe nye no. So keep trying. Keep trying. Keep trying. Obaya no nan osekun don. Keep trying. Be aba cheba kenye bi omo. Nye botwe. Keep trying. No ni feel mi kempanele ke ni bi no ni feel bomoni ote go mi mankene alo fo ya ka oba ya go mankeni wa alo mankeno fo ya ka oba ya go mi e ka obomi to be careful, because you may not find your way back home. Be careful. We're back home. The only thing we are asking of you is to do what is right for the people of God. No baba kokonoko. So call le go me ya, be ready, because you will go there and you will not find your way back home. Bye bye.